I'm 1,000 pieces, still standing tall, a voice in the chaos. I've lived it all. I'm a wife, I'm a mother, a friend in the night, holding a broken, still holding the light. Shells in my pocket, dreams in my hands, building something they don't understand. The crafter of hope from shattered days, finding my strength in a million ways. They don't see the tears fall down in the shower. They don't know the pain behind the power. They only see me when I'm shining bright, not the battles I fight every night. But still I rise through the fire they made, through the hate, through the words they threw in my face. I'm still here, I'm still strong. This is where I belong. Mommy ramblings in my name. I built this boy full of pain. Every rebel that stayed by my side, you're the reason I survive. Still I rise, still I stand, with a broken heart and steady hand. They try to tear me down piece by piece, like I don't deserve a moment of peace. Was it just cause I didn't fit the mold, so they threw their stones and turned so cold? There are things I'll never say out loud, the kind of pain I don't need a crowd, but I carry it deep where the silence lives, and still find a way to give and give. And I smile when I go live like I'm okay, but they don't see the price I'll pay. Missing you with every breath I take, my sweet boy, my heart's still brave. But still I rose for the fire they made, through the hate, through the words they threw in my face. I'm still here, I'm still strong. This is where I belong. Mommy ramblings, this is me. Every left still chasing dreams. Every rebel that never walked away. You're the light that got me through the grave. Still I rise, still out there, with your memory in my head. God, you carried me when I was weak, when I couldn't stand, you lifted me more times than I could ever say. You made a way, you made a way. And I've got dreams that won't let go, a foundation built, some love I know. For my son, for the words he played, I'll turn my loss into something that remains. Yeah, I rise, now I'm stronger than before. Every scar just opened up a door. I'm still here, hear me now. I won't break, I won't bow. Mommy rambling, loud and clear. This is my voice, this is my ear. Every rebel, every heart, you've been with me from the start. Still I rise, still I fight, turning darkness into light.
I'm still your mom,
I still stay your name.
and I'll build something beautiful from all this pain.
Well, hello. Hi, Sandra. How are you? This is a shocker, right? Real shocker. Shocker for me. I thought, if this had come yesterday, I would say April Fools. And then I thought, okay, well, this can't have been decided upon and stuff. And why, it's no April Fool's joke. Not at all. Let me see if you can hear me, Sandra. Let me just make sure. Hold on a minute. Come yesterday, I would say April Fool. Okay. Beautiful. Okay. Sound is very good. Okay. So, yeah, I don't know if you follow the Letecia Stauch case, Sandra, but we covered it from break when Gannon Stauch went missing back in 2020. And horrible case. Did he go, was it 2020 or 2019? It was 2019, wasn't it? Wait a minute, let me just see. It was in like January, was it 2019, right? Why am I thinking 20? It was 2020. I am right. It was 2020. Okay. It didn't seem like... Okay. So he went missing in 2020, January 27th, and we've talked about this case in correlation to Nancy, too, about how the body was absolutely moved, and he was found in a suitcase then over an overpass in Florida. I guess she thought he would go into the river or whatever, but he was discovered. And she was arrested then in South Carolina, and then it was just a crazy time and a crazy case, crazy trial. We covered the trial from gavel to gavel. We covered the case from the get-go, and now, of course, we'll be covering this, every bit of it. So let's look at what's happened today. Now, so from what I know so far, is that the reason the case was overturned, her conviction was overturned, is she gets a new trial. Now, if you, if you're in favor of due legal process, it is a mistake, okay? And if it happened to you or one of your loved ones, you would want them to have a new trial. But the whole fact that this even got that far is just ridiculous. But anyway, one of the jurors had, they said, a bias, potential bias, because they had a son-in-law that worked for the prosecutor, Michael Allen. And so that's what this is all about. Now, we're going to take a look at the legal document. I'm going to put it over here on the screen. Okay, the summaries of the Colorado Court of Appeals. Published opinions constitute no part of the opinion of the division, but have been prepared by the division for the convenience of the reader. The summaries may not be cited and relied upon, as they are not the official language of the division. Any discrepancy between the language in the summary and in the opinion should be resolved in favor of the language in the opinion. Okay, so this is the summary first. People versus Stauch, criminal law, structural error, waiver, invited error, juries, juror bias, challenges for cause, preemptory challenges. Okay, let me just get back so I can see the... Hi, Denise. Hi, Linda. Hi, everybody that's joining us. Welcome. Now, okay. So a division of the Court of Appeals considers whether an erroneous denied challenge for cause is waived or invited by virtue of the fact that the defendant does not use a preemptory challenge to remove a biased juror to correct the trial court's error. The majority finds neither waiver nor invited error in this context, and applying People versus Abu Natambu L. 2019, Colorado 106, includes the error warrants reversal for structural error because a biased juror deliberated. So you had a biased juror deliberating her guilt, right? The dissent concludes that the defendant waived the right to claim error on appeal by exhausting all of her preemptory challenges without excusing the biased juror. So they're saying the defendant, who's Letecia Stauch, waived the right to claim the error on appeal because she exhausted all of her preemptory challenges without excusing the biased juror. Now, judgment reversed and case remanded with directions in the People of the State of Colorado versus Letecia Stauch. Defendant Letecia Stauch appeals the judgment of conviction entered after a jury found her guilty of first-degree murder after deliberation, first-degree murder of a child under 12 by one in a position of trust, tampering with a deceased body, tampering with physical evidence, and multiple crime of violence sentence enhancers, because we conclude that the trial court committed structural error by denying Stauch's challenge for cause to a biased juror who deliberated. We reverse the convictions and remand for a new trial. Here's the background. The prosecution presented evidence at trial that Letecia Stauch brutally murdered her 11-year-old stepson Gannon Stauch in Colorado. She put his body in a suitcase and left it underneath a bridge. I don't think she left it underneath a bridge. I think she threw it over this overpass in Florida. Stauch has pled not guilty by reason of insanity, arguing that she suffered from dissociative identity disorder, but the jury rejected that defense and found her guilty as charged. The trial court sentenced Letecia Stauch to life imprisonment without the possibility of parole, plus 2 consecutive sentences for the 2 tampering convictions. On appeal, Letecia Stauch claims the court committed structural error when it denied her challenge for cause to a biased prospective juror who then deliberated. She also asserts the court erred by denying her request to suppress evidence obtained pursuant to an overbroad warrant and by admitting certain testimony by her ex-husband, Gannon Stauch's father. We agree that the court committed structural error when it denied Stauch's challenge for cause and a biased juror deliberated. Okay, so as a result, her convictions must be reversed because it is likely to arise on remand. We also consider and reject Letecia Stauch's Fourth Amendment challenge to the search warrant. However, we did not reach the remaining evidentiary issue. Challenge for cause applicable law provides that a trial court shall sustain a challenge for cause on one or more of the following grounds: that the relationship within the third party by blood, adoption, or marriage to a defendant or to any attorney of record or attorney engaged in the trial of the case. The existence of a state of mind in the juror evincing enmity or bias towards the defendant or the state, unless the court is satisfied from the examination of the juror or from other evidence that he will render an impartial verdict according to the law and the evidence submitted to the jury at the trial. Jurors who fall within one of these categories are considered biased. That's a matter of law. Hi, Video Reel. We were looking for you the other night. Impliedly biased under subsection 1B and actually biased. So an implied bias under a subsection and actually biased under another subsection, unless they can be rehabilitated. Upon a challenge for cause, the trial court is required to excuse them because, except as described in subsection 1J, if they can be rehabilitated, that is, they cannot be rehabilitated. And then they put in People versus McCrander, the Supreme Court held that when an elected district attorney is the attorney of record, it includes prospective jurors who are related not only to the elected district attorney, but also to the deputy district attorney in the office at the time the jury selection occurs. Okay, and then it said overruled on other grounds. Okay, that is the statute that directs automatic removal of a juror related with the third party, the third degree, to any deputy district attorney in the elected district attorney of record's office, regardless of whether the deputy district attorney appeared or participated in the case. This preserves the appearance, if not the reality, of fairness in a criminal prosecution and public trust and confidence in the criminal justice system. Because think about it. If you have a juror that's working in the prosecutor's office with the prosecutor who's prosecuting this case, someone that's related to a juror, very close relation to a juror, couldn't the prosecutor then be getting information? He could potentially getting information about how the jury's feeling, what he needs to do to convince the jury, and all of that. And you can't have that. Okay? As part of the voir dire, the prospective jurors completed a questionnaire that included a question about whether they had friends or relatives in law enforcement. prospective juror M.B. indicated, now listen to this, that his son-in-law worked with the El Paso district attorney. Son-in-law, the juror's son-in-law. During follow-up questioning, juror M.B. confirmed that his son-in-law worked as a deputy district attorney in the same office as and for Michael Allen. So not only, this person is not clerking, okay? It's not some college student with an internship. This son-in-law is the deputy district attorney in the same office as the prosecutor, Michael Allen, who is prosecuting the case. Okay, prosecuting attorney. Defense counsel later identified juror M.B. among the prospective jurors he wished to challenge for cause. When the court asked for more detail, defense counsel explained, his son-in-law works for Mr. Allen. The prosecutor in court then made the following comment. So the defense voiced their opinion. They're like, hey, this juror here, hey, come on. Son-in-law works for Mr. Allen. Now the prosecution said this. They said, I hate to agree with defense counsel, but the follow-up questions were never asked. How that's gonna impact his ability to be a fair and impartial juror, and that certainly doesn't rise to a level of statutory cause. So we would object to him being released for cause. And then the court says, yeah, is this a joke? I'm gonna circle back to that one too. Probably when I'm gonna do is not excuse juror M.B. at this point and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause, and I didn't hear anything else about that fact creating an issue or conflict or something else. Are you kidding me? Are you kidding me? It is unbelievable. Hi, Melanie. How are you? It is unbelievable. Very unbelievable. So, okay. So they said, this is crazy. I tend to agree, and I don't think it's a statutory cause, and I didn't hear anything about that fact creating an issue or conflict or something else. I don't run across those sets of facts very often, so I just need to think about that one, and it may be that I decide it next week. He's gonna decide it. The prosecutor suggested that the court ask further questions of the juror M.B., and the court agreed. Defense counsel objected. I think the record is what it is. And I guess the only thing I think that there is, a difference between somebody saying, I have a son or daughter who works for the police, than I have a son-in-law who works for the DA, who is actually trying the case. And so I think that's where it becomes different. Even if it was a different district attorney, other than his son-in-law's direct boss who is trying the case, I think it would be different, and I'll leave it on that. The trial court brought the prospective jurors back into the room, and they asked juror M.B. how long his son-in-law had worked for the district attorney. And remember, he's not working for the district attorney as a clerk, right? He's not working as like some little gopher from a summer internship or something. He's the deputy district attorney. So they asked how long, right? And whether that the juror M.B. had discussed the case with his son-in-law, and whether juror M.B. might be influenced by a desire to have the case work out better for his son-in-law. And based on his answers, the court instructed that the juror M.B. to return the next day. He was not ultimately dismissed. Now, isn't that out of an abundance of caution? But they should have dismissed this person. But why would they keep this person on in this type of a case, this is just so crazy. Okay. The Attorney General does not dispute that Juror M.B. fell within the category described in Section 1610-103-1B because he was related within the third degree to his son-in-law, who was a deputy district attorney in the prosecuting district attorney's office. We are bound by the Supreme Court's determination that his bias was implied by law. Of course, it doesn't matter what they said. There's such an implication of bias, right? Oh my gosh. Nevertheless, the Attorney General argued that reversal is not warranted because it's not clear from the record whether Juror M.B. deliberated. It's not clear from the record whether he... Hey there, bug girl, how are you? The Attorney General also asserts that defense counsel's challenge for cause was not properly preserved and that counsel either waived or invited the trial court's error. We are not persuaded by these arguments. 1. M.B. deliberated. Our review of the record demonstrates that Juror M.B. deliberated. Okay, we all know what deliberating is, right? They're deciding her guilt or innocence. Indeed, the trial court granted Letecia Stauch's motion to settle the record on the point, removing any doubt. 2. The challenge is properly before us. The Attorney General first argues that Letecia Stauch failed to properly preserve her challenge for cause because counsel did not explicitly cite 1610-103-1B and did not correct the trial court's purported misunderstanding that the challenge for cause was based on something other than a statutory ground. The Attorney General further asserts that defense counsel's comments after making the challenge for cause suggest that the challenge was based on Juror M.B.'s actual bias, subject to rehabilitation, not his implied bias, based on his relationship to the prosecutor. For the reasons discussed below, we conclude that the court considered and ruled on a statutory challenge for cause under Section 1610-103-1B. Therefore, the challenge is properly before us. To begin, we recognize the defense counsel's challenge for cause potentially implicated two different subsections of Section 1610-103. We recall that the statute requires the court to sustain a challenge for cause on one or more grounds, including implied bias based on a relationship to attorney of record, subsection 1B, and actual bias, subject to rehabilitation, subsection 1J. That is, defense counsel could have based his challenge on Juror M.B.'s relationship to the prosecutor, subsection 1B, or his state of mind resulting from that relationship, subsection 1J. Given this context, we reach two conclusions from the record. First, we conclude that counsel's stated reason, his son-in-law works for Mr. Allen, was sufficient to trigger a ruling under subsection 1B. Second, even if it were not clear solely from counsel's challenge to Juror M.B., on which part of the statute counsel was relying, we nevertheless conclude the prosecutor's and court's subsequent comments brought subsection squarely into play for purposes of our review. See People versus Melendez. Okay, but the trial court must be presented with opportunity to rule on the issue. As prosecutor correctly observed, at the time of the challenge, neither attorney had asked any questions to elicit whether Juror M.B. had a state of mind evincing enmity or bias. Okay. Without these questions, there was no way to tell whether Juror M.B. should be excused for actual bias under Section 1610-103-1J. Having recognized this, the prosecutor continued to note that the challenge certainly didn't rise to a level of statutory cause. In this context, we conclude the prosecutor could only have been referring to statutory cause based on implied bias under the subsection 1B. The trial court's subsequent comments likewise suggest its awareness of the distinct for cause challenges under subsections 1B and 1J. The court first said, "I don't think it's a statutory cause," and then noted that it didn't hear anything else about that fact creating an issue or conflict or something else. These comments indicate a cursory and improper rejection of a challenge based on the relationship itself under 1B. Okay, so what they're saying is, look, just the whole relationship that this person is related, this juror going to deliberate this case is related to the deputy district attorney who works under the DA who is prosecuting this case. That should have been enough, okay? All right. Based on that relationship itself. Followed by a separate consideration and rejection of a challenge based on a biased state of mind under subsection 1J. Despite the Attorney General's arguments, we do not read these statements as demonstrating confusion about the nature of defense counsel's challenge. Instead, read in context, we conclude the trial court statement, "I don't think it's a statutory cause," reflected the court's mistaken belief that Juror M.B.'s implied bias based on his relationship to the prosecutor as distinct from his actual bias as a result of that relationship did not trigger mandatory removal under section 1610-103-1B. In other words, the trial court was not questioning whether defense counsel was making a statutory challenge for cause based on the relationship itself. Instead, and critically for purposes of our review, we read the trial court statement as expressing its inclination to deny the challenge for cause on both grounds. When the trial court ruled on the claim raised on appeal, it is properly before us, People v. McPhee, defense counsel's subsequent argument that the situation might be different if the juror's son-in-law worked for the police or for a different district attorney other than his direct boss who is trying the case. Does not change the result, okay? So because they said that doesn't change the result. As the Attorney General acknowledges, that argument went to whether Juror M.B. should be excused for actual bias under 1610-103-1J, and the trial court had already rejected the challenge under section 1610-103-1B. As a result, defense counsel was under no further obligation to restate his objection. Now, the record further supports this reading. In addition to Juror M.B., defense counsel identified juror number 8 among the jurors he wished to challenge for cause. He explained that juror number 8 had indicated on his questionnaire that he could not be fair in a case involving child abuse, was not sure he could set aside information he had heard about the case, believed a not guilty by reason of insanity plea was a ploy to excuse the alleged crime, and was never asked about any of that. By contrast, when asked for his basis for challenging Juror M.B. for cause, defense counsel simply said, "Yeah, his son-in-law works for Mr. Allen." So they also had a problem with juror number 8, okay, that they identified and said they wished to challenge. Now that's pretty significant on number 8 because they're saying that they said they could not be fair in a case involving child abuse. And we know Gannon's case involved child abuse, right? And they said they believed a not guilty by reason of insanity plea was a ploy. And that's what she was using, okay? And he was never asked for anything about that. And also the third part was that juror said that they couldn't set aside information they already heard about this case. So craziness, and they weren't asked any questions. Okay, so Yeah, his son-in-law works for Mr. Allen. Obligation to restate his objection. See People versus Coughlin. Okay. Likewise, the defense counsel did not cite 1610-103-1B is of no moment. The Attorney General relies on People versus Savelis Acosta, in which a division of this court declined to consider the denial of a challenge for cause because defense counsel did not specifically cite section 1610-103-1K. But in Savelis Acosta, defense counsel moved to challenge the juror for cause because he would place authority on the testimony of a police officer over anybody else, not based on the mere existence of a relationship covered by the statute. This case is distinguishable. Defense counsel's initial challenge for cause succinctly stated that Juror M.B. was related to the prosecutor. Unlike Savelis Acosta, counsel did not argue that Juror M.B. might have an actual bias in favor of the prosecution. And as discussed, even if defense counsel's comments left any doubt, the prosecutor and trial court expressly acknowledged and dismissed the possibility of a statutory challenge based on a relationship itself. On these facts, we conclude the trial court was on notice of the particular ground for the challenge, even without a specific reference to section 1610-103-1B. See People versus Comar. An argument that goes to the subject matter of a statute without citing the statute directly sufficiently preserves the matter for appeal. See also People versus Cognac. Challenge for cause was preserved even though it was not expressly for cause because the context made it clear it was a challenge for cause. The error was neither waived nor invited. Waiver is the intentional relinquishment of a known right or privilege. People versus Rediger. We indulge every reasonable presumption against it. Invited error, by contrast, prevents a party from complaining on appeal of an error that the party invited or injected into this case. It is a narrow doctrine and applies to errors in trial strategy, but not to errors that result from oversight. Okay, hang on one second. I just have to move something into a folder here. Hang on 1 minute. Okay, sorry, how to just do that. Okay, back again. The Attorney General asserts that defense counsel waived or invited the trial court's error by failing to clarify the basis of the challenge after the ruling suggested that the court was confused about the grounds for the challenge. But we have already concluded that the trial court's comments did not indicate that it misunderstood the nature of the challenge for cause, only that it did not believe excusal was warranted. So what they're saying there is that they've already concluded that the trial court's comments didn't indicate that it misunderstood anything here, but they just said that they thought that it didn't require the juror to be excused, right? Given the reading of the record, the foundation of the Attorney General's waiver invited error argument collapses. In any event, even after Juror M.B. answered the trial court's follow-up questions, defense counsel said, "I maintain my objection to Juror M.B." This ongoing objection suggests there was no waiver. Hey, Trix, I know, right? I was floored too. I thought it was April Fool's. I'm like, oh gosh, is this an April Fool's joke or what? Come on. I know, it's crazy, isn't it? This is nuts. She's going to get a new trial. Can you believe this? The family has to go through all of that again. And we know we're going to have the same outcome. I'm not worried about the outcome. She's guilty as anything, right? She's guilty as all get out. Come on. But the family has to go through that again Do you remember how many days we covered the trial from gavel to gavel here. I have the playlist here. Remember how many days it was, the phone calls we had to listen to, everything? That's all going to have to be done again. And the family has to go through that. And even though they know, she's guilty as everything and that's going to come shining through, the family has to go through that again. I just can't even believe this. But you also, if you are, in favor of due process, you see the mistakes here and you can't overlook them. I mean, it's just crazy. Nor can we conclude that defense counsel waived or invited the error by failing to use peremptory challenge to excuse Juror M.B. The law does not require criminal defendants to use peremptory challenges to preserve an unsuccessful challenge for cause. To the contrary, the Supreme Court has held that its prior decisions do not require a defendant to cure a trial judge's error on a challenge by using a peremptory strike against the objectional juror in order to preserve a claim that his right to a fair trial was violated by the presence of a biased juror. So what they're saying is there's nothing on record that a defense counsel has to, use their peremptory strike to get rid of a juror because the trial judge is making an error. So they're not required to do that. So, you can't just say, oh, okay, well, they should have just done that if that's what they wanted, All right. By using the preemptory strike against the objectional juror in order to preserve a claim that his right to a fair trial was violated by the presence of a biased juror. Indicates that there is no inherent inconsistency in allowing counsel to challenge a juror for cause while also permitting her to use peremptory challenges to excuse other jurors. We recognize that the majority, in this case Abu Nantambu L, declined to consider whether waiver or invited error might apply in such situation because it was not raised on appeal. Nevertheless, the majority suggested, albeit in dicta, that even if it were to entertain an invited error argument, it would find no invited error because the record did not suggest that defense counsel purposely failed to use a peremptory challenge to remove the implied biased juror, the impliedly biased juror. Similarly, we see no suggestion of invited error here, and particularly in light of defense counsel's ongoing objection, we see no suggestion of waiver in the record. The Attorney General relies on Justice Samour's dissent in Abu Nantambu L, expressing the defense's counsel decision not to use a peremptory challenge to excuse a juror after the loss of a for-cause challenge in a classic example of waiver or invited error. Like Justice Samour, the Attorney General suggests that counsel may simply request, and trial courts may be encouraged to grant, an additional peremptory challenge, but, as in Abu Nantambu L, the record here lacks any indication that defense counsel was acting strategically. So they're saying if defense counsel disagrees, they could just use, one of their peremptory challenges to remove that juror, but you can't just say because they didn't that they were acting strategically or something, right? See Garcia finding no inwitted error under the same circumstances. Additionally, we are not persuaded that defense counsel should be required to use a peremptory challenge to excuse a biased juror after the court erroneously denies a for-cause challenge. So what they're saying is that, hey, defense counsel doesn't have to use one of their peremptory challenges just because the trial court erred. The trial court was mistaken. The trial court made an error. That's not what has to happen here. So, see Abu Nantambu L. Moreover, nothing prevents the prosecution from using a peremptory challenge to remove a juror who should have been excused for cause. Hello, Sassy. Nor are we persuaded that defense counsel may re-level the playing field simply by requesting an additional preemptory challenge. So they can say, okay, can we have another preemptory challenge so that we can, use that against this juror? But they don't have to do that. So our Supreme Court has consistently recognized the type of error implicated here, a violation of the defendant's right to an unbiased jury. See, and this is important, okay? I understand, like, we're all, oh my gosh, she shouldn't be getting a new trial, this and that. But guys, the error that was made here, if it was made in your case, if it was made in the case of your relative or anybody, you would be fighting for that. So you have to understand this is about due process, okay? And because of this, like, nobody wants her to have a new trial. We know she's guilty. We know a new trial is going to also convict her and that it's going to be terrible for the family to have to go through this. But what is right? What is right is this is wrong, and this would be wrong in anyone's trial. Sassy, they had a juror who was the deputy, who had a son-in-law, okay? A juror that deliberated in Letecia Stauch's case, who's...
Jimmy Sell.
Oh, hang on 1 second. My husband. Hello. I'm doing a live. Yeah. Okay. All right. Love you. Bye. Okay. Sorry about that. So what they're doing is he was the son-in-law of Sassy, was the deputy district attorney working under Michael Allen, who prosecuted this case. And they brought it up and they didn't do anything about it, really, okay? So that's not right, because just think about it, just the implied bias, the implications that, maybe nothing of this happened, but couldn't that deputy district attorney keep Michael Allen? Couldn't he? I mean, isn't there an implication that that juror could be biased to the point that they're talking to their son-in-law, who's then talking to Michael Allen and giving him, an unfair advantage in what the jury's thinking, what the jury needs, where the jury's sitting. Do you know what I mean? So, yeah, it's like that juror should have been taken off. And then there was another juror there was an issue with beyond that, but this is really the crux of it. And this is what you have to understand, this is a violation of any defendant. Something like this, they have a right to an unbiased jury. That's just the facts of it, okay? You would want that. You would want it for a family. You would want that for anybody. So, again, I have no doubt with a whole new jury seated, right, which is going to be the case, she's going to get a new trial, that she's going to be found guilty. I have no doubt. There's not even a doubt in my mind. But the family has to go through this all again, and this could all been prevented. It's hindsight now. You can't go back. But it's just, if you're looking at it and if you care about, due process, this is a violation. So this is absolutely a violation. So our Supreme Court has consistently recognized this type of error implicated here a violation of the defendant's right to an unbiased jury, and so harmful that it warrants automatic reversal. It's so harmful, it warrants automatic reversal. See People versus Flockhart. Okay? Structural errors require automatic reversal without individualized analysis of how that error impairs the reliability of the judgment of conviction. The harm arising from a biased adjudicator, okay, a biased person that is making a judgment, that's deliberating, pervades and infects the entire framework of the trial. That's the crux of this. It's not just, you're mad, oh, Letecia shouldn't get, no, this is a structural error. This is so bad, okay? Abdu Nantambu L. Citation omitted, and because maintaining the integrity of the judicial process is in the interest not only of the accused, but of the public. See, that's what I'm saying. It's not just because how it affects Letecia, it's how it affects everyone. Because if this is allowed, then let's just say, you have somebody that's a defendant or you're a defendant sometime, then if they let this go, okay, it could also affect another case. So you can't just say, oh, it's fine, she's guilty anyway, no big deal. No, it's a really big deal. Okay, see People versus Nazolino. But the biggest deal is why didn't they excuse this juror? Why did they let something like this happen? Right? Why? And now, because of that, the family has to go through this again. They have to testify again. They have to bring up all that pain again. All of that again. Okay? They have to come face to face with the defendant again. It's ridiculous. We are not inclined to infer waiver from defense counsel's failure to use a preemptory challenge to correct the trial court's error. Reversal is required when the trial court erroneously denies a four-course challenge to a biased juror. The defendant exhausts her preemptory challenges and the biased juror serves on the jury. The error is structural, okay? There it is. When a trial court makes an error, okay, and refuses to remove a biased juror, the defendant exhausts her preemptory challenges. She doesn't have any more. And the biased juror serves on that jury. Then the error is a structural error. The result of the legislator's determination that certain relationships render a potential juror impliedly biased is that the juror is deemed as a matter of law to be biased, period. Where there's an implication, okay, where you could imply, like we could say, how do we know that the juror is not talking to her son-in-law is not talking to Michael Allen, where we can see there may be an implication, well then no, then it's just deemed biased, period, as a matter of law. Such is the case here. Accordingly, Letecia Stauch's convictions must be reversed. And then they talk about the search warrant, because Letecia Stauch is also challenging the court's denial of her motion to suppress evidence that was obtained from a search of her cell phone. So let's just read this first. Although Justice Samour's dissent suggests that encouraging judges to grant requests for additional preemptory challenges under the statute would re-level the playing field, we are not so sure. After all, defense counsel would necessarily premise a request for additional preemptory challenges on the court's prior wrongly denied challenges for cause, rulings made by the same judge, and we're not confident that the same judge would grant additional preemptory strikes on this basis. So whether she had to ask for additional preemptory strikes, that they're not saying that would necessarily remedy this problem. Because this issue is likely to impact the proceedings on remand, we elect to address it. So now they're going to elect to address her problems with the search warrant. So in denying Letecia Stauch's motion to suppress, the trial court acknowledged that the warrant to search Letecia's cell phone was broad, but it concluded that its breadth was necessary, given the scope of Letecia's conduct after Gannon Stauch went missing. Stauch argues the court erred because the warrant violated the Fourth Amendment particularity requirement. We discern no error. So what they're saying there is that it was overly broad the search of her phone. Okay, that they should have specified a time frame. I don't understand where it would make much issue, because the damning evidence, right, the searches and everything would have fallen under what you would presume would be a timeline that would not be overly broad, okay, because it was right in that time frame with Gannon Stauch going missing, slightly before, slightly after, right? So what they're saying here is that even though it was broad, it was okay because of like it says here, it says her conduct. So all this stuff she was doing after Gannon Stauch went missing, even though it was overly broad, her conduct warranted that, and they don't see any error in that. So that's good. So that doesn't mean that they're going to be suppressing any evidence, which is wonderful, which means that she will be convicted again, but the family should not have to go through this. Okay. Applicable law, the Fourth Amendment protects individuals against unreasonable searches and seizures. A search conducted pursuant to a warrant is typically reasonable. People versus Koch 2020. However, so-called general warrants, which permit a general exploratory rummaging in a person's belongings, are prohibited. To prevent a general exploratory search, a search warrant must be sufficiently particular as to enable the executing officer to reasonably ascertain and identify the things to be searched for. So we've all seen the search warrants when they put it there. They're putting like why this should be happening and what particularly they're looking for and where and whatnot, right? We've seen them all a million times covering cases. People versus Rodriguez-Ortiz, because cell phones contain so many different types of private data, warrants to search them must be carefully scrutinized. To be sufficiently particularized, warrants for the search of data on cell phones must include specific limitations based on 1, the type of alleged criminal activity, 2, the identity of the alleged victim, and 3, the time frame. If applicable, within which the suspected crime occurred. And I think all of this stuff on her is 100% on that. When evaluating whether a warrant is sufficiently particular, we must look at the totality of the circumstances, reviewing the warrant and any accompanying affidavits in a practical, common sense fashion to determine if probable cause exists. Even if a warrant lacks particularity on its face, an affidavit submitted in support of the warrant may cure its lack of particularity if the deficient warrant incorporates the curative affidavit by reference. So what they're saying is even if their search warrant doesn't have the particularity on it, as long as they reference the affidavit and the affidavit has that, it can cure the problem, okay? So both documents are presented to the issuing judge or magistrate, and the curative affidavit accompanies the warrant during the execution of the warrant. So as long as they're keeping those two documents together, that can be sufficient. A trial court suppression order prevents a mixed question of fact and law. We accept the court's finding of fact if they are supported by competent evidence, but we assess its legal conclusions de novo. Additional facts. The investigating detective sought a warrant to search Letecia Stauch's cell phone for the following. Okay, so this is what they did. Data that may identify the owner and user of her device, address books and calendars, audio and video clips related to the above described criminal activity and further described in this affidavit in support of the search warrant. Call histories, call logs, and visual voicemail related to the above described criminal activity and further described in this affidavit in support of the search warrant. So they're referencing the affidavit there, right? Yes. Photographs and associated metadata related to the above described criminal activity and further described in this affidavit in support of the search warrant. Yes, Maria Kitty Cats, yes. Can you believe this? She has a new trial. Automatic because of their error in excusing a juror whose son-in-law was the deputy district attorney under the prosecuting attorney, Michael Allen, in this case. Now, this part is about the search warrant. I don't think she's going to be successful here. Text messages, SMS, multimedia messages, MMS, recorded messages, and subscriber information modules, SIM cards between the cell phone owner and co-conspirators involved in the above described criminal activity and further described in this affidavit in support of the search warrant for the above described items. Email messages and attachments, whether read or unread and related to the above described criminal activity and further described in this affidavit in support of the search warrant for the above described items. Internet, World Wide Web browser files, including but not limited to browser history, browser cache, stored cookies, browser favorites, autocomplete form history, and stored passwords. Global Position System, GPS data, including but not limited to coordinates, waypoints, and tracks. Documents and other text-based files related to the above described criminal activity and further described in this affidavit in support of the search warrant for the above described items. Applications, apps, and other installed programs, including widgets and any data stored by the application or remotely stored by application server or database server. Any and all computer software, to include but not limited to operating systems, applications, utilities, compliers, interpreters, communication programs, or any digital information which can be interpreted by a computer or any related components which may be stored in. Yeah, they have to live it all over again. Yeah, but it's if you care about due process, Marie Kitty Cats, it is wrong. You know, we have to understand that. But it's on the trial judge here that just the court erred. Electronic, magnetic, optical, or other digital form, any and all data stored within any computer storage device. See, this is overly broad, yes, but it's supported by the affidavit. And does the warrant this? Yes. And or other processing or storage devices to include but not limited to computer applications, images, videos, text programs, encryption routines, algorithms, or any other data that may be decoded, reconstituted, or otherwise manipulated to produce, utilize, transmit, receive, encrypt, encode, or display such images, videos, text programs, encryption routines, and algorithms. With respect to these items, the warrant authorized police, with the aid of a law enforcement computer forensic laboratory, to view, photograph, record, copy, forensically image, and conduct forensic analysis of any and all metadata programs and applications on the above described devices, as well as on any data stored devices and or mediums attached to or installed in those devices. The warrant incorporated an affidavit detailing Gannon Stauch's disappearance and Letecia Stauch's conduct thereafter, including Letecia Stauch's refusal to cooperate with police, conflicting statements and behavior, ongoing communication with family members, and social media posts. The affiant submitted that it was necessary to search Letecia Stauch's cell phone to ascertain her past location and communications and to aid in locating Gannon Stauch, who was still missing at the time. Letecia Stauch argues that the warrant to search her cell phone was overly broad because it allowed police to access anything that might be on her cell phone with no temporal limitations. While she acknowledges that the affidavit was incorporated by reference into the warrant, she argues that it broadened the scope of the search even further by allowing a search for anything that could be used as evidence against her. We disagree. True, the warrant itself did not describe the type of alleged criminal activity, identity of the victim, or time frame within which the crime occurred, but it specifically incorporated the warrant application and supporting affidavit that did. The warrant limited the search to the items specified in the application, and that application in turn attached the 4-page supporting affidavit and made it part hereof. The affidavit described how on January 27, 2020, Letecia Stauch called to report Gannon Stauch, 11 years old, her stepson, missing, stating that he had left her house on foot and had not returned. I remember this day. It continued to describe how during the subsequent 40-hour period, Letecia Stauch refused to meet with police or provide requested information, was unaccounted for during part of the day when Gannon Stauch was reported missing, that she called in sick to work for an unrelated reason and had been continuously communicating with her daughter, husband, and other family members via text messages and Facebook. The affidavit also described that Letecia Stauch met with police 2 days after the report, when she substantially changed her statement regarding Gannon Stauch's disappearance. Letecia Stauch initially suggested that Gannon Stauch went to his friend's house and didn't return. But at the police station, she said that he was abducted by a carpet repair person who had SA'd her at gunpoint. Do you guys remember how crazy this was? How crazy? We have to revisit this. This is crazy. For those of you that don't know about this case, the affidavit went on to describe a roll of carpet with blood on it that was found in a storage area inside the Stauch's house. It also stated that Letecia's cell phone was linked to her doorbell camera security system. And based on its specific incorporation of the affidavit, which was signed by the issuing magistrate and accompanied the search warrant during its execution, we conclude that the warrant was sufficiently particular. See Rodriguez-Ortiz. Stauch agrees otherwise based on Stauch argues otherwise based on Koch, in which the court found a warrant was sufficiently particular because it contained no limitation as to the alleged victim or time period during which the crimes occurred. But, as described above, the warrant and affidavit here specifically described Letecia Stauch's conduct during the 40-hour period after Gannon Stauch went missing. See Rodriguez-Ortiz. Cell phone warrant was sufficiently particular because it incorporated an affidavit describing period of investigation. While the warrant was broad, the affidavit was specific. It described conduct limited to those 40 hours. It clearly identified Gannon Stauch as the victim, and it detailed inconsistencies in Letecia Stauch's conduct and story in the aftermath of his disappearance. The fact that a warrant was broad was not dispositive when it covered a 6-month period. The affidavit identified the victims in specific crimes, and the defendant's conduct and communications surrounding the crimes were relevant to identifying him as the suspect. Moreover, many of the categories described in the warrant were expressly limited to items related to the above described criminal activity and further described in this affidavit. While not every category included the same limiting language, the warrant's incorporation of the attached affidavit served the same function. The warrant satisfied particularity requirement on this basis, even if it could have been more particular. So even if they could have made this more detailed, more particular, put more dates, that affidavit, that warrant, because it was with the affidavit, it satisfied everything there. Because the warrant and affidavit read together limited the search of Stauch's cell phone to a specific time frame, victim, type of criminal activity, the warrant did not allow for a general search. Instead, it targeted a specific set of data that allowed police to establish Letecia Stauch as a suspect. And I don't understand why she's doing this. I understand why she's doing this but when we look at all of the stuff that was put into evidence, it was all in that time frame that was relevant based on that affidavit, right? See Rocaforte, a broad search warrant is nonetheless permissible when the requested evidence is justified by the nature of the crime or crimes. We therefore conclude that the Fourth Amendment's particularity requirement was satisfied, and Letecia Stauch's motion to suppress was properly denied. See, had she got the new trial and had they said that this search warrant was overly broad and that a lot of this was going to be suppressed, then we'd have problems, but it's not going to be. Because we conclude that the warrant and affidavit were sufficiently particular, we do not address whether the good faith exception applied. Suppression based on an overbroad warrant is not required when officers act in objectively reasonable reliance on a warrant issued by a neutral magistrate. We also decline to address Stauch's remaining evidentiary contention because it's unclear whether or how the issue will arise on remand. Okay. Disposition. The judgment is reversed and the case is remanded with directions. Judge Gomez concurs. Judge Bernard, concurring in part and dissenting in part, assume a court erroneously denies the defendant's challenge for cause to hypothetical juror A. Then assume the court also denies the defendant's challenges for cause to hypothetical jurors B, C, D, E, F, G, and H. Next, assume the defendant has 16 preemptory challenges. She uses 7 of those preemptory challenges. Sounds like word problems in school. I'm probably losing a bunch of you, right? She uses 7 of those preemptory challenges to remove jurors B, C, D, E, F, G, and H from the jury, and the other 9 challenges to remove prospective jurors whom she did not challenge for cause. But she does not remove juror A, who sits on the jury that ultimately convicts her. In this situation, does she waive her right to contend she is entitled for a new trial because of the court's error? I would answer this question yes, because the majority answers the question no. I respectfully dissent from the portion of Part 2C3 of the majority's opinion concluding defendant Letecia Stauch did not waive the error the trial court made when it denied her challenge for cause to Juror M.B. I concur with the majority's determination in Part 2C3 that the court erred in when it denied the challenge, and with the majority's analysis of the Fourth Amendment issue in Part 3C. I also address the issue the majority does not discuss. Did the trial court err when it allowed the prosecution to present evidence concerning the defendant's prior manipulative behavior to rebut her defense of not guilty by reason of insanity? Because I do not believe the court erred, and I would affirm the defendant's convictions. The interplay of challenges for cause, preemptory challenges, and the waiver doctrine. Waiver. Where are you going? You going to the gym? What? What is that? Oh. All right, be careful. Love you. Okay. Structural errors, even those impinging on fundamental constitutional rights, can be waived. Stackhouse versus People. A defendant can waive her right to a public trial at her right to challenge a prospective juror who was the wife of the judge presiding over her case. That's, wow. Richardson versus People, and a right to object to a judge presiding over a case who had, while working as a public defender, previously represented her. People versus Garcia, and by pleading guilty, she waives a number of constitutional rights, including some that could lead to structural error if erroneously denied, such as the right to a trial by jury and to a public trial. People versus Jennings. Waiver is the intentional relinquishment of a known right. Forget versus people. Waivers may be explicit when, for example, a party expressly abandons an existing right. Waivers may also be implied when the party engages in conduct that manifests an intent to relinquish a right or acts inconsistently with its assertion. When deciding whether a waiver was implied, the record need only show that a defendant or a counsel made a conscious decision to forego raising a claim for an objection for strategic or other reasons. Cardman versus people. We do not presume acquiescence in the loss of fundamental constitutional rights, and we therefore indulge every reasonable presumption against the waiver. People versus Curtis. Okay. A short history of preemptory challenges in Colorado. Hang on for a minute. If you're listening to me, can you just put up a 1 so I know that you're here listening to me? That'd be nice. I understand some of you are listening and doing other things, and I appreciate that, but every once in a while, just let me know you're here. A short history of preemptory challenges in Colorado. The United States Supreme Court has long recognized that preemptory challenges are auxiliary, unlike the right of an impartial jury guaranteed by the Sixth Amendment preemptory high video reel. Challenges are not of federal constitutional dimension. United States versus Martinez Salazar. See also Rivera versus Illinois. If a defendant is tried, hey, thank you, what's up? How are you? Before a qualified jury composed of individuals not challengeable for cause, the loss of preemptory challenge due to the state court's good faith error is not a matter of federal constitutional concern. The way Colorado courts view preemptory challenges has changed significantly over the last quarter century. Hey, apple cakes. Over the last quarter century. Before 2014, our Supreme Court required the reversal of any criminal conviction in which the defendant used a preemptory challenge to remove a prospective juror following an erroneous denial of her challenge for cause, and ultimately exhausted all the preemptory challenges available to her. Right? People versus Novotny. In 2000, the Supreme Court expanded the scope of this automated reversal rule to include the erroneous grant of prosecution challenges for cause, reasoning that such error gave the prosecution an unfair tactile advantage. But in Novotny, our Supreme Court abandoned the automatic reversal rule because both federal and state law governing harmless error reviewed in general, and the lack of constitutional significance of preemptory challenges in particular, have developed so as to substantially erode. Hey there, B, Jaden, how are you? Good, doing good. Thank you for listening. Have developed so as to substantially erode the premises upon which the automatic reversal rule rested. The court replaced the automatic reversal rule with an outcome determinative rule based on the harmless error standard of Criminal P 52A. An error will be disregarded unless it affects substantial rights, which requires evaluating the likelihood that the outcome of the proceedings in question were affected by the error. Under the harmless error standard, if a juror biased against the defendant sits on the jury, such an error is structural because it violates, see, there it is again. See, they're just saying, you can't have a biased juror on the jury. It's a structural error, right? And then because it violates the defendant's right to an impartial jury, and the appellate court must therefore reverse the defendant's conviction. And that's what happened here. That's exactly what happened here. Hi, Apple Cakes. You said, hello, this case is disgusting. I can feel her vindictive happiness about this. Ugh. Yeah, but you know what? She was also hoping she was going to suppress evidence from that search warrant. Listen, there is no doubt, absolutely none, that she's going to be convicted again. But yes, how horrible the family has to go through all that again, right? But she does not use one of them to remove a juror. So it says, The majority of Novotny did not address the scenario we face in this case. Does a defendant waive the error if she uses all her peremptory challenges, but she does not use one of them to remove a juror whom she challenged for cause, and the trial court erroneously denied that challenge? So what they're saying is that if she already challenged, hi Jim K, if she already challenged this juror, she could have used one of her peremptory strikes, challenges, to get that juror off, right? So if she doesn't choose to do that, even though the court made the error, does that make it a non-issue? I'm just trying to sum it up in layman's terms, right? And now this is going to be discussed right here. I will discuss the next issue. Hi, Jen Girl. Preemptory challenges and waivers. Some might say that, at least under federal law, the issue in this case has already been decided by the United States Supreme Court in Martinez Salazar. Excuse me a minute. The government can urge the Supreme Court to read federal law to require a defendant to use a peremptory challenge to strike a juror who should have been removed for cause in order to preserve the claim that the for-cause ruling impaired the defendant's right to a fair trial. The Supreme Court rejected this invitation, reasoning there was no federal law demanding that a defendant use or refrain from using a peremptory challenge on a particular basis, or when a particular set of facts is present. The court recognized that there is one obvious exception to this statement. The Equal Protection Clause prohibition of exercising a peremptory challenge to remove a potential juror solely on the basis of the juror's gender, ethnic origin, or race. This language, some would suggest, shows the United States Supreme Court rejected the application of the waiver doctrine to situations such as the one in this case, but I submit there are 3 reasons why Martinez Salazar did not do so. First, the language is dicta. See Whiting versus State. Second, in a concurring opinion, Justice Scalia pointed out the issue before the Supreme Court was not whether a defendant should be required to use a peremptory challenge curatively when a trial court has erroneously denied a challenge for cause. Martinez Salazar. Scalia J. concurring in the judgment. Rather, the issue was whether a defendant's actual use of a peremptory challenge to effect such a cure impinged upon his ability to exercise all his peremptory challenges under federal R. Crim. P. 24B, and the majority had concluded the exercise of the defendant's peremptory challenges has not been adversely affected. Justice Scalia was far from certain that the court's analysis of the use of peremptory challenges was correct. It's easy enough to agree, he continued, that we have no warrant to read into federal R. Crim. P. 24B, a requirement that peremptories be used to remove veteran properly challenged for cause. The difficult question, however, is not whether federal R. Criminal P. 24 requires exercise of peremptory, but whether normal principles of waiver disable a defendant from objecting on appeal to the seating of a juror he was entirely able to prevent. So what they're saying is, okay, the court made an error, right? But is the defendant, because she didn't use that peremptory waiver of, oh my gosh, why am I losing my words right now? Peremptory challenge to strike that juror. Because she didn't use that, does that excuse the error and act like, okay, well, you didn't use that, so you were just fine putting in the biased juror on the jury to decide your fate, right? So, yeah, that's, imagine Gannon would be 18 this year. Isn't that amazing? Yeah. Yeah, absolutely, because he was a year younger than my son Luke. And I covered this case from the start, and I covered the trial from gavel to gavel. After this appeal, does she have any more? She's got a new trial. Appy Cakes, she has a new trial. There's a new trial. That's what I'm saying. This is not something that's going for, this is decided. Her conviction has been overturned. Then he added, I would not find it easy to overturn a conviction where, to take an extreme example, the defendant had plenty of preemptories left, but chose instead to allow to be placed upon the jury a person to whom he had registered an objection for cause and whose presence he believed would nullify any conviction. Third, Martinez Salazar concerned a rule of federal criminal procedure, not a rule of state criminal procedure. See Browning versus State. While Martinez Salazar is the law in case involving federal criminal procedure, it is not law which requires any change of course from this court. See also State versus Talbot. The part of Martinez Salazar pertinent to this issue is not based on any legal principle that applies to these states. Okay, so we'll just go here. Martinez Salazar may have left open the issue of whether, under federal law, normal principles of waiver disable a defendant from objecting on appeal to the seating of a juror that he was entirely able to prevent through the use of a preemptory challenge. So again, they're saying, if she was able to prevent this, shouldn't it be no point? Because if she had a problem with this juror, and even if the court erred, why didn't she use a preemptory challenge to remove this juror? And the fact that she didn't, does that just say, you don't have to worry at all, B. Landon, she is going to be found guilty. That's not the issue, and she's not going to suppress any evidence either with that search warrant crap. But the family has to go through this whole thing nonetheless, right? Okay. The Martinez-Salazar opinion applies only to federal case. It is not binding upon state courts. In other words, it does not set out a constitutional rule controlling state courts. There is a potential Colorado counterpart to Martinez-Salazar. Shortly before Martinez-Salazar came out, a division of this court decided People versus Morrison. The division concluded because the defendant chose not to excuse the jury in question by use of the preemptory challenge, the court's denial of his challenge for cause does not have the effect of reducing the number of preemptory challenges that he could exercise. As a result, the defendant failed to demonstrate how the court's denial of his challenge worked any prejudice upon him. But in this case, it's very prejudicial. It really is. And if you care about due process, even though you don't want to see Letecia Stauch get a new trial, you can't say that this is, fair trial. It's not. It's not. My bad. I meant if she gets convicted again, hopefully and likely she will that be it? Or will she then... I'm sure since it's a new trial, she will have appeals, yes. Just because they're granting her a new trial. They're not holding this conviction. So we hold that the trial court did not abuse its discretion in denying that the defendant's challenge for cause because the jury in question stated that she could fairly hear the evidence. Because the trial court did not commit any error concerning this juror, we need not base our decision on how the defendant responded to what he perceived to be an erroneous detail of a challenge for cause. We consequently find it unnecessary to determine whether a defendant suffers an impairment of his right to use preemptory challenges if he exhausts his preemptory challenges but does not use one of his challenges against a juror who he originally challenged for cause. In such a scenario, the controlling question is whether the defendant's constitutional rights to an impartial jury were violated by the presence of a biased juror on his jury. And this one is 100%. As a result, the division's rationale incorrectly relied on our Supreme Court's precedent because those decisions do not require a defendant to cure a trial judge's error on a challenge for cause by using a preemptory strike against an objectionable juror in order to preserve a claim that his right to a fair trial was violated by the presence of a biased jury. So what that means is Letecia or any defendant doesn't have to use one of their preemptive challenges because the trial judge made a mistake to cure that. And they don't have to use one of their preemptive challenges to cure that mistake and then say, oh, ha, ha, you didn't use it, so nothing counts here. You could have used it. It's not their responsibility to use something to cure the trial court's error. The trial judge should not have made the error. That's bottom line. The defendant has no obligation to fix that, right? And did it result in a biased jury, implied bias? Yes, it did. Okay, so citing Martinez Salazar, the court wrote that regardless of whether the defendant chose to use a preemptory challenge on the allegedly objectionable juror because he challenged the juror for cause and she served on the jury, his right for an impartial jury was violated if this challenge for cause was improperly denied. So yeah, she had a problem. She had a biased jury, implied bias on there. The opinion proceeded to discuss whether the record showed the trial court had erred when it denied the defendant's challenge for cause, ultimately concluding the trial court had not erred. This isn't another case, okay? Fast forward 19 years to Abu Nantambu L, in which the trial court erroneously denied a challenge for cause based on Section 1610-1031K, CRS 2025. The majority described the issue in that case to be as follows: what standard of reversal applies where a trial court erroneously denies a challenge for cause, the defendant exhausts his preemptory challenges, and the challenged juror ultimately serves on the jury? The majority answered the question this way: we conclude that the erroneous seating of the impliedly biased juror is a structural error and requires reversal. As a result, such an error is not amendable to analysis under a harmless error standard, regardless of the juror's actual bias. So it doesn't matter if the juror was biased or actually, it's implied. If there is an implication that that juror could be biased, and they shouldn't be sat on that jury. The majority did not address the issue whether the waiver doctrine applied in those circumstances because the prosecution had not raised the issue. Justice Samore dissented. After arguing that the juror was biased and should not be allowed to serve, Justice Samore wrote, the defendant turned around and elected not to excuse her with one of his 12 preemptory challenges. As a result, Justice Samore thought the defendant had either waived or invited the error. So here they're saying that, okay, this defendant that raised the question of this bias upon this juror had 12 preemptory challenges. That's 12 strikes. We want that juror off, right? Because after the trial court, right, said, oh, it's okay, and then Justice Samore said, because the defendant didn't use their challenge, well, then they either invited the error or they waived it. But Justice Samore asked, would one unfair shortcoming of his approach be the defendant's always losing? He had this covered, encouraging trial courts judges to grant a defendant's request for an additional preemptory challenge under Criminal P 24D3 whenever they deny a Colorado challenge for cause, i.e. one that is difficult to resolve and presents a close call. So could they ask for an additional one and to strike that juror? Now here's the analysis. I conclude for the following reasons. The defendant waived the error the trial court made when it denied her challenge. Now this is directly about Letecia now. When it denied her challenge for cause to Juror M.B. She waived the error because she did not remove Juror M.B. with a preemptory challenge, although she had 16 available for that purpose. The issue is preserved. Unlike Abu Nantabu L., the prosecution raised the issue of waiver in the answer brief in this appeal. The issue has not been decided in Colorado. Martinez-Salazar only applies to federal cases. See Browning, Talbot, blah, blah, blah. Okay. Morrison did not resolve this issue either. The Supreme Court stated it need not base its decision on how the defendant responded to what he perceived to be an erroneous denial of a challenge for cause. The court also said it's unnecessary to determine whether a defendant suffers an impairment of his right to use preemptory challenges if he exhausts his preemptory challenges but does not use one of his preemptory challenges against a juror who he originally challenged. Our Supreme Court resolved the appeal by concluding the trial court had not erred when it denied the defendant's challenge for cause. Harkening back to Justice Scalia's concurring opinion in Martinez-Salazar, Morrison's discussion of not requiring a defendant to cure a judge's error on a challenge for cause by using a preemptory challenge was dicta. See Abdu Nantamu L. Morrison was decided 14 years before Novotny, so as an artifact of the error of the automatic reversal rule. It's unclear how much of Morrison's reasoning is still viable since it was rooted in that now discarded rule. And in Abu Nantambu L., our Supreme Court stated that this issue has not yet been decided. I am aware the division in People v. Garcia stated Morrison's holding was in part that its previous decisions do not require a defendant to cure a trial judge's error on a challenge for cause by using a preemptory strike against the objectional juror in order to preserve a claim that his right to a fair trial was violated by the presence of the biased juror on his jury. Relying on this holding, the division rejected the prosecution's invited error contention. So the prosecution saying, oh, look, they invited the error because if they didn't agree with it and the judge made an error and put that juror on, they should have just used one of their, strikes and got that juror off. And they're saying no. There's nothing that says that the defendant has to do that. You say, Appy Cake says, Letecia is an evil narcissistic POS, but I agree. The case should be retried due to the juror error and fairness overall. I wonder if a different juror would have changed the outcome. No, I don't think so. But, again, and if you care about due process and stuff, you can't just let stuff like this go. It's not right. It's not right, and you've got to be unbiased whether, however you feel about Letecia, you have to put yourself in that position or someone you care about, and you would never want to know that they had a jury that was implied bias. You had someone whose son-in-law was the deputy district attorney working under the prosecutor that was prosecuting this case is crazy. Why would, oh my gosh. Okay. Where were we? Trial judge's error of a challenge by using a presumptive. Okay. Relying on this holding, the division rejected the prosecution's invited error contention. But I think the division put more weight on the quoted language in Morrison than the language bears, because it was a dicta. Siabu Nantambu L. In any event, I am not bound to follow the Morrison division's reasoning. See People versus Smoots. One division of the Court of Appeals is not bound by the decision of another division. Requiring parties to use preemptory challenges to cure jury selection errors is a good idea whose time has come in Colorado. It is a general rule that all matters pertaining to the qualifications and competency of the prospective jurors shall be deemed waived by the parties if not raised prior to the swearing in of the jury to try the case. So, if a defense attorney waives any error related to a challenge for cause by not making the challenge in the first place, or if the attorney waives the same type of error by not exhausting the peremptory challenges allotted to the defendant, then how does that same lawyer preserve the error by making the challenge for cause, having it erroneously denied, and then failing to remove the juror? With an available peremptory challenge. Why should two acts of these acts, not making cause challenge at all or not exhausting all available peremptory challenges, be subject to the waiver doctrine, while the third, not using a peremptory challenge to cure an erroneous ruling on a challenge for cause, not by subject to the doctrine? In the third situation, the lawyer had the power to remove the biased juror, elected not to do so, and now wants to complain about that election on appeal. This is especially true when looking at the relationship between challenges for cause and peremptory challenges. The history of these two types of challenges indicates peremptory challenges have always had a curative purpose. There are significant institutional costs to rejecting the application of the waiver doctrine in cases such as this one. The salutary purposes of the contemporaneous objection rule are particularly important in jury selection. We want to encourage the trial court's opportunities to correct jury selection error for the very reason that we are at the beginning of the whole process. There are obvious and enormous judicial economies in correcting jury selection errors when they are made rather than with an appeal and a retrial. By electing not to remove biased jurors peremptorily, defendants participate in the seating every bit as much as the trial judges who erroneously fail to remove them for cause. So what they're saying is now, hey, should a defendant, if they feel that, hey, Dookie, that there's a juror that they've, exercised problems with to the judge, say, hey, this juror has a son-in-law that works in the district attorney's office as the assistant DA, and then the judge, even erroneously, says it's okay. Should the defendant bear the responsibility of having to use a peremptory challenge to remove that juror? And if they don't, shouldn't they waive the ability to appeal on that because of the enormous expense that doing that and having a retrial present, right? That's what they're saying. So shouldn't that ultimately fall, if the court makes a mistake, shouldn't that ultimately fall on the defense, the defendant? That's what they're saying. Okay? So to correct the trial judge's errors is not hard. The defendant is in a position to correct the trial judge's error early and easily. So the trial judge makes an error, and hey, use one of your challenges there, right? That's what they're saying. Simply by using an available peremptory challenge to strike the problem juror. And this remedy is far superior by any legitimate institutional measure to letting the biased juror sit through an entire trial and then reversing the conviction and ordering a new trial. Martinez-Salazar did not suggest that states are prohibited or even discouraged from requiring parties to cure alleged jury selection errors with their peremptory challenges. Indeed, There are good reasons to require parties to use their available peremptory challenges to cure jury selection errors. Doing so promotes a defendant's right to receive a fair trial in the first instance, and prevents unnecessary retrials, encouraging trial courts to be open to granting additional peremptory challenges when the decision to deny a challenge for cause is a close one, would cure any unfairness created by the application of the waiver doctrine. Crim P 24D3 states, for good cause shown, the court at any time may add peremptory challenges to either or both sides. I agree with Justice Samour's suggestion in his dissent in Abu Nantambu L that we should encourage trial court judges to grant a defendant's request for an additional peremptory challenge whether they deny a colorable challenge for cause, i.e., one that is difficult to resolve and presents a close call. Hi, Melanie. The defendant could then use the extra peremptory challenge to remove the juror. So now they're saying, like, should they be allowed an extra one so that they're not saying, hey, why do I have to use my peremptory challenges to cure the judge's error? And now I've lost one of mine, but would they grant me one in order to do that, right? The remedy would, 1, classify the denial of a challenge for cause that is difficult to resolve and presents a close call as good cause for granting an additional peremptory challenge under Crim P 24D3. 2, eliminate reversible error if the defendant used the extra peremptory challenge to remove the juror she previously challenged for cause, even if the court erred when it denied the challenge, because a biased juror would not have served on the defendant's jury. 3, mean that the defendant would waive her ability to challenge the trial court's ruling on the challenge for cause on appeal if she did not use the extra peremptory challenge to remove the juror previously challenged for cause. 4, require the appellate court to reverse the defendant's conviction if the defendant asked for an additional peremptory challenge, the trial court denied the request, the juror who had been unsuccessfully challenged for cause served on the jury, and the appellate court concludes the court erred when it denied the challenge for cause. 5, disincentivize the prosecution from opposing colorable challenges for cause, Abu Nantabu L, Samour J dissenting, and 6, give trial court judges some comfort in knowing that the additional peremptory challenge would cure the erroneous denial of colorable challenges for cause. 5, even if defendants should not be required to use peremptory challenges to cure jury selection errors, defendant nonetheless waived her right to challenge the court's decision to deny her challenge for cause to Juror M.B. It is my view that this case represents Justice Scalia's extreme example, Martinez Salazar, which I believe is not as unusual as Justice Scalia thought. Defendant knew she had challenged Juror M.B. for cause, and why? Okay, so they're saying Letecia Stauch knew that they challenged Juror M.B. And why? Because they had a son-in-law that was the deputy district attorney working under Michael Allen, who was prosecuting this case. Letecia, used all 16 of her peremptory challenges, including 7 of them to remove other jurors whom she had challenged for cause. Yet, although she was obviously aware she could use any of her 16 peremptory challenges to remove Juror M.B. from the jury panel, she chose not to do so. She therefore knew Juror M.B. would remain on the jury panel. and she did not ask the trial court for an additional peremptory challenge under Crim P 24D3 for the express purpose of removing Juror M.B. So she had no peremptory challenges, and she didn't ask for another one, they're saying. I conclude this combination of awareness and deliberate conduct was intentional, and it was an implied waiver of the defendant's right to challenge the trial court's erroneous decision to deny her challenge for cause to Juror M.B. on appeal. So was this strategic, is what they're saying? Did they think this is intentional and strategic by Letecia that she didn't ask for another peremptory challenge or use one of the ones she had to remove this juror, right? So I conclude this combination of awareness and deliberate conduct was intentional, and it was an implied waiver of the defendant's right to challenge the trial court's erroneous decision to deny her challenge for cause to Juror M.B. on appeal. Defendant could have cured the trial court's error, but through her counsel, she engaged in conduct that manifested an intent to relinquish her right to remove Juror M.B. from the jury. Which amounted to a conscious decision to forego her right to challenge the trial court's error on appeal. So, did that conscious decision forego her the right to use this in an appeal, right? See Martinez Salazar, Scalia concurring in judgment. I now turn to the remaining appellate issue. The majority does not address. Testimony about manipulative behavior. Defendant asserts the trial court erred by allowing the prosecution to rebut her insanity defense by introducing evidence showing she had previously been manipulative. I disagree. Defendant objected, so Letecia Stauch, we are talking about now, objected to this evidence, adding the court should analyze it under CRE 404B. The prosecution replied that the evidence was relevant to the defendant's mental condition. The court decided CRE 404 did not apply. I will assume for the purposes of discussion, the manipulation evidence was a form of a bad act evidence. Yet I would nonetheless conclude the court did not err when it admitted it. Before Colorado switched to its present unitary trial system, the law bifurcated sanity and guilt trials when defendants pled not guilty by reason of insanity. Generally, evidence of prior criminality of an accused is not admissible. Prior bad acts. You probably heard that, right? Prior bad acts. However, in a bifurcated insanity trial, this rule is relaxed since the prejudice that may occur by the admission of such evidence is lessened by a separate trial on the issue of guilt. People versus Bieber. Courts in other states have decided that defendants, by pleading not guilty by reason of insanity, make much of their entire life history relevant. See State versus Hurls, People versus Hauser, People versus Woody, People versus Santorelli. I therefore conclude the evidence of the defendant's manipulation would throw light one way or the other on the issue of the defendant's sanity, Hurls 914P 2D, and that it would strain the rules of evidence to hold that the prosecution is precluded from introducing evidence to counter a defendant's claim of insanity solely because the evidence involves the defendant's previous immoral or unlawful conduct. Santorelli 401. But what if this reasoning does not apply to Colorado's present unitary trial system? Even if I thought the trial court's decision not to apply CRE 404B was error, I do not think it is reversible error. A conviction will not be overturned on appeal when the trial court used an erroneous standard in analyzing the admissibility of evidence if the evidence was admissible and the proper foundation was laid for its admission. People versus Cousins. The record supports a determination that the manipulation evidence was admissible under CRE 404B and under the four-step test. Announced in People versus Spotto. The evidence related to the material fact of whether the prosecution could prove beyond a reasonable doubt that the defendant was sane at the time of the crime was logically relevant to this material fact because it provided a basis for testimony that some of the defendant's conduct was manipulative, meaning she was malingering her claim of a mental disease or defect. Hey, Jordan Thomas. Yes, it is true. She gets a new trial, and it was a court error. They seated a juror on the trial that deliberated in Letecia's case, whose son-in-law was the deputy district attorney under the prosecutor, Michael Allen. Was logical, relevant to this material fact because it provided a basis for testimony that some of the defendant's conduct was manipulative, meaning she was malingering her claim of a mental disease or defect. Had logical relevance independent of the prohibited inference that defendant committed the crime on account of her bad character because it gave the jury information with which to assess the validity of her insanity defense, and it had a probative value that was not substantially outweighed by the danger of unfair prejudice. See CRE 403, because the defendant's manipulativeness did not have an undue tendency to suggest a decision on an improper basis, commonly but not necessarily an emotional one, such as sympathy, hatred, contempt, retribution, or horror. People versus James. Accordingly, I would affirm defendant's convictions. Where the heck is 53 and 54? Okay, so now hang on a minute here. Let me go to... Hold on a second. I've got to get something else here. Hold on a moment. Let's see. Okay. So this is a 54-page ruling, okay, from the Colorado Court of Appeals. It's the official decision to reverse the conviction of Letecia Stauch and grant her the new trial. The court determined that a structural error occurred during jury selection. It compromised the fairness of the original trial. Specifically, the error involved a juror, identified as Juror M.B. in the document, who was allowed to remain on the jury despite having a clear conflict of interest. Now, what that conflict of interest is their son-in-law was the deputy district attorney under the prosecutor, Michael Allen. The core of the appeal was about the juror M.B., whose son-in-law was the deputy district attorney in the same office that was prosecuting Letecia Stauch. Under Colorado law, if a juror is related to one of the attorneys in the case or someone in their office, they are considered to have an implied bias. Okay, as a matter of law. It doesn't matter. You don't have to prove they had an actual bias. It's an impliedly bias. It's impliedly so. It's implied bias. That's it as a matter of law. The trial court's mistake during jury selection. Letecia Stauch's defense challenged Juror M.B. Okay, for cause. Meaning they asked the judge to remove him, right? Because, hey, his son-in-law is the deputy district freaking attorney, okay? What are you doing? However, the judge refused to dismiss him. Judge made an error, mistakenly believing that the juror could be rehabilitated if that juror promised to be fair. The appeals court ruled that because the bias was implied by law due to the relationship, the judge was required to remove him immediately, and because he didn't, that's the judge's error, okay? Why does this mean there's a new trial? Because Juror M.B. actually sat on that trial, actually deliberated the verdict that convicted Letecia Stauch, which meant that her right, okay, and again, this is not about how you feel about Letecia. This is about how you feel about the legal system in this country and due process and everyone's right to a fair trial. You've got to take Letecia Stauch out of this because her rights were violated. And you would never want yourself, your family member, your friend, anyone to do that. So it is entirely right that she gets a new trial. Do we like it? No. Why? Because she's guilty like crazy. She's going to be convicted again. She has to put the family through this. Nobody likes that part of it. No one. But ultimately, this judge made this error. Now, the other argument in here, right, they went on and on about should a defendant have to use a peremptory strike to get a juror off there if the judge makes an error, be the curative solution for that judge's error. No, you can't, so, okay, so let me go on about this a little bit more. In the legal world, this structural error is so fundamental that it infects the entire framework of a trial. It cannot be ignored, and therefore the original guilty verdict was thrown out. Okay? She also then tried to argue, and this is good, that this is a small win for the state, but she argued the search warrant was overly broad, okay? She said that the police illegally searched her phone using an overly broad search warrant. However, as we read here, the appeals court rejected that argument. They ruled that the warrant was specific enough because it was accompanied by that affidavit, right? Because it was tied to the 40-hour window right after Gannon went missing, that Letecia's behavior warranted that. And so it means that the evidence from her phone can still be used in the new trial. So that's a small win for the state. That would be terrible if that was thrown out, right? So what does this mean now? The verdict is gone. The previous conviction for first-degree murder and other charges is now void. The case is being sent back to the El Paso County District Court. It's a do-over, a start-over. A new trial is going to have to be scheduled. A new jury is going to be picked and seated. Prosecution will have to present the case all over again. And Letecia will remain in custody while she's awaiting these new proceedings. One judge on the panel disagreed with the reversal. And that's what we just read as well. He argued that because the defense had 16 peremptory challenges, extra picks to remove jurors, right, and chose not to use one on Juror M.B., that they essentially waived their right to complain about it later. However, since 2 of the 3 judges voted to reverse it, the majority opinion is what becomes law. So that one judge that I just read to you that said that the conviction should stand was in the minority. So her conviction is thrown out. Just so you know that. It's thrown out. So, oh boy. What do you guys think about that? I thought, if this would have happened yesterday, I would have thought it was April Fool's. I really did. I said, what is this? This cannot be true, or this has got to be just, an appeal motion that hasn't been decided on. I could not believe she had a new trial. But then when you hear about it, you have to, if you care about due process, there's no way around it. So let me see what you guys are saying. Okay. Does everybody understand why she gets a new trial? Do you understand that? Jordan's not getting notifications. Yeah. So, now, how many of you here followed the Gannon Stauch case? Because we covered this case from the beginning. When Gannon Stauch went missing, we were on this case all throughout all of the craziness with Letecia. And then in 2023, May of 2023, and it might have started in April, we, gavel to gavel, we had the live trial coverage. We will do that again. We will cover this case again, gavel to gavel. Okay. I remember I was in South Carolina when she was found guilty. We still had it streaming. I believe I was in a Buc-ee's in Florence on my way home to New York when she was found guilty, and I stopped to talk to you guys about the verdict, but we had everything streaming here. Every day that trial was streaming. So, but I think maybe since this happened in 2020, and that is 6 years ago, some of you, like a lot of you, sometimes have come to true crime either through Nancy Guthrie or another case, and you didn't follow true crime before and you didn't know of these cases. So probably go over all of the evidence that's in this case. And believe me, there's no doubt in my mind that regardless of what jury is seated, she's going to be found guilty. There's not a doubt in my mind that she's going to get off. Not one doubt. That's not what the issue is. The issue is the family has to go through this again. Now, I'm thinking like, would you offer any deal that so they wouldn't have to go through this again? But no, I think she enjoys the attention. And I don't know how any of her jail calls and stuff after the fact are going to come into things, but or any of her, her past behavior or things she might have said to cellmates and things like that now can be also used. So anyway, how many of you have followed this? Not too many from what I see. How many are still here watching this? I see the numbers here, but I'm not seeing how many of you followed this. I know a lot of you are listening and doing other things, but if you could hit those likes, share this out, that would be very nice. Holy Thursday today. It's a horrible day, but you usually do find these days are horrible and overcasted and reminiscent of what the time was like back in Jesus' day. Yeah. Okay, so let me get, hang on a minute. Let me look at one thing, okay? And if you want to watch, I put a link. If you want to watch her first trial, because like I said, we covered it gavel to gavel, there's the link to the playlist in the video description. I'm also going to put the link to all the Gannon Stauch videos that we did from the time of his disappearance. Okay, and yeah. Let's see what else we have. And this is Gannon Stauch, who was 11 years old, Letecia's stepson, who she killed. She was convicted of killing, and that conviction has now been overturned. Let's see here. Craziness. All right, now this is, what's this here? Hang on one sec. She actually wrote out her appeal here. Right, relief sought. Plaintiff names the court. Plaintiff moves the court for a temporary restraining. What is the, this is order as plaintiff has found extreme retaliation for filing the original complaint for failure to. Oh, this is something different. Hold on. Motion for temporary restraining order from Letecia. Let's see what this is. Why can't I make this larger? Let me make this here because I don't have my glasses on. Okay. As plaintiff has faced extreme retaliation for filing original complaint for failure to protect. This is April 10th, 2025, about a year ago. First Amendment rights. The restraining order sought will restrain defendants I guess these are their names, Dina Hook and Dalton Hartpence, from retaliation, abuse, and does that say anti-Semitic behaviors? As a result of filing legal action for failure to protect defendants, have placed the plaintiff in an RHU restrictive housing unit from August 2024 to current without a hearing or any justification. Remember, she was getting tracts in her peanut butter and stuff. Remember all of the craziness? Plaintiff is listed as a general population resident and has not had any disciplinary reports from August 2024 to current. However, the placement in an RHU was retaliation for filing and failure to protect. Plaintiff was placed in a pod 4 where the failure to protect happened with defendant Dietrich, the accused, as the officer in charge from August 2024 to December 2024 before he was removed. During this time, plaintiff was attacked by a mental health patient in front of a, what was that, captain? And hang on. Harassed by a transgender resident With S crimes against women, defendants said the plaintiff should learn her lesson for filing the failure to protect and that the negative efforts would continue if she did not drop legal actions. Plaintiff has remained what is that? DC free or DR free for 10 months and has followed all rules. I believe that's disciplinary, right? Has followed all rules of defendants even while they were retaliating. Plaintiff asked when she could be removed from RHU, restricted housing unit, as she was not in there for disciplinary, and defendants responded that the retaliation would end when she dropped all civil actions. The message was relayed to her by a captain. The retaliation continued, and on April 7, 2025, the plaintiff left Pod 3 for chow with officers Eleanor, who worked down the hallway with her, and called over the staff radio that she was walking down to meet another officer who was waiting for her at the dining hall. Topeka Correctional has followed this procedure for the plaintiff for 9 months since being housed in RHU as a general population resident and has been authorized by ISGT Johnstone, Kidwell, Caldo, Bernhardt, and several TCF officers on April 7th, 2025. Plaintiff did just that. Passed the defendants Hook and Hartpence along the way. As she followed direct orders from officers, defendants retaliated and said that even though she followed orders of officers, she would face punishment because she continued to pursue legal claims. Defendant Hook said plaintiff should enjoy wearing yellows as a result because the Seador would go good with the Star of David. The color would go good with the Star of David. Hook was mocking plaintiff's First Amendment clarified in this case for the denial of practicing her Jewish religion at TCF. Plaintiff did not receive any disciplinary reports or break any rules at TCF during this incident as she followed an officer's order. However, defendants have told staff that the plaintiff could not be served any food, use the phone, take a shower, or leave her room at this time. Captain Thompson called First Sergeant Cobb and relayed this message. Cobb and Valdina came to plaintiff's door on 4/9 and relayed the message. All staff involved admit that this is a retaliation from Hook and Hartpence, but are afraid of retaliation themselves. All officers involved admit the plaintiff followed their orders and that defendants are imposing the punishment because plaintiff filed a failure to protect claim. Plaintiff is asking the court to order Hook and Hartpence to stop the retaliation, to return the plaintiff to normal status as no DRs or reports were issued, to stop the anti-Semitism, and to stop denying plaintiff a shower, food, and other rights of general pop residents. Hang on, one more page. The plaintiff's losses would be repairable if the defendants continue to fail to protect and disseminate on religious rights. Defendants are now handing down punishments that are cruel and unjust and are discriminating, and retaliation is clear. The harm imposed is physical, emotional, and mental, and is irreversible. The court is aware of physical harm of no food, no shower, or exercise, movement, and continuing to fail to protect. In addition, the mental harm of continued retaliation without DRs since August 2024, and of mocking the Jewish faith, the potential injury to the defendant by the TRO sought could not possibly counterbalance the irreparable injury to the plaintiff if defendant's conduct is not restrained. Plaintiff contacted all parties involved to rectify the issues without success. Plaintiff also has had family contact, KOOC Heather Cummings, and she said that nothing could be done because none of this was in policy, and that KOOC did not retaliate. Plaintiff then failed TRO, and a copy was served to Holly Chavez and the warden's office, and KDOC Letecia Stauch, April 10th, 2025. So let's see what's happening here. There's another, what is this? Letecia Stauch versus Jeff Zamuda. Hold on one second. There's going to be another trial for her in Topeka, 3-day trial. What is this about? Hold on a second. On January 28, 2026, U.S. Magistrate Judge Brooks G. Severson conducted a pretrial conference in the case by phone, and this is a case Letecia Stauch versus Jeff Zamuda. Plaintiff Letecia Stauch appeared pro se. She's representing herself. Defendant Jeff Zamuda, Darcy Holdhast, Donna Hook, Holly Chavez, Dalton Hartpence, this is in relation to this, and FNU Dietrich appeared through counsel Matthew L. Sugar and Lisa Montgomery. The pretrial order supersedes all pleadings and controls the subsequent course of this case. Okay, the subject matter jurisdiction is invoked. Let's see what's going on here. Plaintiff raises an Eighth Amendment claim about an SA that occurred at TCF in October of 2023. Officer Dietrich SA'd the plaintiff in the Pod 4 shower area. The SA occurred when Officer Dietrich reached his hand through the hole in the middle of the shower door and he grabbed the plaintiff's breast. Plaintiff informed defendants Chavez, Hook, and Zamuda of the abuse through the emergency grievance procedures, and they failed to act on the abuse. I think I've covered this. Plaintiff then faced retaliation after reporting the SA, and defendants failed to protect the plaintiff from the abuser. Next, the defendant tampered with legal mail and confiscated legal mail, causing delays. I think this is around the time our peanut butter had tracks in it. Prison officials interfered and failed to assist the plaintiff in bringing legal actions and delayed the plaintiff the right to access the courts and tampered with legal mail. Finally, defendants violated the rights to free exercise and equal protection. Plaintiff was forced to change religion to attend church. She was denied access to Jewish practices and did not have equal access compared to male inmates or inmates of other religions. Okay. Defendants deny that the SA alleged by the plaintiff occurred. Defendants also submit that the plaintiff's accounts of the alleged assault are implausible, considering factors such as the physical dimensions of the shower area and the restrictions on visibility. Other defendants were not deliberately indifferent to any SA because KDOC initiated an investigation into the matter, and the investigation determined the plaintiff's claims of SA were unsubstantiated. The reason Jewish services with other inmates did not occur at TCF in IMAX while plaintiff was housed there was because the plaintiff was the only inmate in that location who designated her faith as Jewish. Jewish religious gatherings only occur when multiple inmates in the same location designate their faith as Jewish. Defendants did not prohibit the plaintiff from attending church services or otherwise burden the plaintiff's religious practices. To the extent any defendant burdened plaintiff's religious practices, it did not occur due to any discriminatory purpose, but in support of legitimate peniological interests and or compelling governmental interests. Okay, so this is going to go to a trial in Topeka. Plaintiff requests $50,000 in compensatory damages and $75,000 in punitive damages for counts 2. For counts 1, 2, and 3, the plaintiff requests that an injunction be granted to prevent continued violations. Okay, so it says trial. This trial of this case is estimated for 3 days in Topeka, Kansas. The case will be tried by the court sitting without a jury, a bench trial. The court will subsequently set this case for trial following a determination of the motions for summary judgment. The parties have indicated that they will file. And that was January 28th, 2026 in Wichita, Kansas. That was signed. Interesting, right? Let's see what else we have here. Okay, so yeah, that's what it is. For those of you that are just coming in, the previous conviction for the first-degree murder and other charges is now void. Okay, she gets a new trial. That's a given. She gets a new trial. That's a done deal. Case is back in the El Paso County District Court. New trial has to be scheduled, new jury picked. And prosecution is going to have to present their whole case all over again. She's going to remain in custody while awaiting the new proceedings. And I went through the entire document. Let me see who's here. Let's see. Okay. Hi, Jet set up. What is the general consensus as why she did this? Why she did what? I went over the whole thing in depth. The Jet said it's because there was a juror that was on the jury that deliberated who had a son-in-law who was the deputy district attorney under the prosecutor. That's an implied bias. And that's anybody that cares about due process, that's not okay, right? Even though whatever we feel about Letecia, that she's guilty and we know that she's going to be convicted again, in interest of due process, that's wrong. It is. It's wrong. You wouldn't want it if you were there. You wouldn't want it if a family member was there, a friend, or whatever. You can't have that. And you can't say, oh, it's on the defense. They should have just curated the judge's error by using one of their strikes there. Okay? Two of the judges were in agreement that this is structural error. It's immediate. Just overturn this conviction. The one had a difference of opinion. I went through the whole document. Hi, Bucky Ann. So, yeah, that's everything there in a nutshell. We will be covering this again. We did cover this from gavel to gavel, the trial, and the whole crime from the time that Gannon went missing. And I'll put that the gavel to gavel playlist is there, and I'm going to put Gannon Stauch's playlist for the whole crime is there. Yeah, you have to. You have to, Jet Set. You have to. That's. I mean, you know what I mean. You just can't have something that's not right. So no matter what we feel about it, it is the right thing. She needs a new trial, but it's got to put the family through craziness. So, how many of you have followed the Gannon Stauch case from the start? I don't think very many of you that are here did. "11-year-old boy who went missing in January of 2020. First, Letecia said he was at a friend's house and didn't come back. And then her story got weird. Her story got so weird. Oh my gosh.
Letecia Stauch was horrible.
You did, Jen? Oh, you did too, Bucky? Okay. How many other people did? You watched every day the trial, yeah. Because I think you were here by the trial, but the whole case started in 2020, 3+ years before the trial. If you want to, let me see if I have the, hold on a minute. Hold on a minute. I'm looking at something, just 1 second. Just thought about something. I just thought about something.
Honey, you should have told me to stop the store.
This might be a good introduction for people that have not heard of it to watch the opening statement, because when they lay out the story, hold on a minute. Why can't we? There we go.
And she took action to hide those crimes. His back, all stout. Yeah.
All right, let's see now.
Yeah, we went for scheduled for tomorrow the 4th.
10:45 a.m., right?
10:45 a.m. and I have a notification on for that. You are not, it's not been activated.
All right, let me see into it.
Fine. GPS location data.
Promise. He promise. Pinky promise. Okay. All right, so listen. We're all right. We're gonna have to sell stuff to fix it. Okay. So we figure out what we gotta sell. We can sell the sofa. We can sell whatever, because we gotta get it fixed. So, lady, don't be mad at us and kick us out the house. Okay. You got it. You got it.
I'm just worried about my
Okay. Shh. Listen. So tomorrow.
The other person in this case is that last voice you just heard, who said so tomorrow. This lady sitting right here, the defendant. January 26, 2020, and into January 27, 2020, she was the sole provider for Gannon. Her husband, Al Stauch, Gannon's father, serves in the National Guard. He was in Oklahoma for National Guard training, left that Saturday night, the 25th. Everything that happened to Gannon from that point forward was her decision. She carried out actions to kill Gannon, to put his body in a suitcase and hide it, to hide evidence of what she did to Gannon. Told numerous stories to investigators to manipulate the course of the investigation. And finally, to discard Gannon inside that suitcase off of a Florida bridge like garbage. January 27, 2020, Gannon's home, located at 6627 Mandan Drive, here in Colorado Springs, Colorado, turned into the stuff of nightmares. In fact, the one place a little boy like Gannon should have felt the safest, his bedroom, turned into, like I said, the stuff of nightmares. That bedroom is in fact where he was brutally murdered. The defendant attacked him viciously, mercilessly, deliberately, and intentionally. These are exhibits that you'll see from the doctor down in Florida, Dr. Ignacio, when she performed the autopsy. He'll tell you that Gannon suffered 18 stab wounds to his body, his chest, his back, his head, and most importantly, his arms and his hands. Why is that important? Gannon was fighting for his life, and those were defensive wounds. Next came a crushing blow to his head that was so strong, it fractured his skull like an eggshell. That wasn't enough for this defendant. He retrieved a 9mm handgun, fired it at Gannon 3 times. 2 bullets struck the pillow near him and were caught in the fibers of that pillow. That 3rd bullet entered his jaw, traveled through his head, fracturing his mandible, his vertebrae, hitting his spinal cord, and lodged in the back of his head and was recovered at autopsy. Gannon's life drained from his body, drop by drop. The photo that's on the screen right now is a picture of his bedroom. Same corner where he was in that picture, or where you'll see him in the picture in the bed. Each one of those markers signifies a small blood drop that splattered across his wall. It ran down the corner of his mattress, soaked through the carpet padding, and puddled on the concrete foundation below that carpet. The defendant then took very deliberate action. She decided to hide her crimes from the world, and she took action to hide those crimes from the world. She collected Gannon's bloody and broken body and the blankets and pillow that were near him and shoved them into a suitcase and hid them in the storage unit in that basement. That basement storage unit is right around the corner from Gannon's bedroom. What she didn't know is that she was leaving clues behind in that storage room. That plastic tub that you see in the bottom left portion of that picture has Gannon's blood on it. There was an Amazon box in that storage room that has Gannon's blood on it. The concrete floor in that storage room had Gannon's blood on it. The defendant next decided to clean Gannon's room.
This is the quickest way to clear out stuck poop.
Why does Grandma's tummy look pregnant?
Deliberately, intentionally, knowing what she was doing. She scrubbed the walls, cleaning them off. She scrubbed the carpet with scrub brushes that were later found in the dishwasher. Those scrub brushes have carpet fibers in them. They have blood on them. They have Gannon's DNA on them. This is Gannon's bedroom when members of the El Paso County Sheriff's Office first came to the house on January 27th in the evening hours. This is what it looked like. No obvious signs of a struggle. No obvious signs of blood as they walked through the house and through Gannon's bedroom. There were no obvious signs of a struggle or a murder because the defendant had cleaned them up. And also realized she had Gannon's blood on her person. Clothes that she was wearing, likely containing Gannon's blood, based off of how much blood had hit the walls, were never found. Her clothing was never found. These shoes, the defendant's shoes, were found on the washing machine, drying. That reddish rust color that you can see on the soles, Gannon's blood and DNA were found on those shoes. You can see just how much blood she was walking through as she was cleaning up that mess. Took more deliberate action. She collected and discarded other important clues. I mentioned she stabbed Gannon 18 times. The instrument that she used to stab Gannon has never been found. That 9mm handgun that she used to fire 3 rounds at Gannon, shell casing ejected out of that firearm each time she pulled the trigger. No shell casing was ever found in Gannon's room. She then took more deliberate action when she hid Gannon in a suitcase, first in her car, and then up north near the El Paso County, Douglas County line. GPS location data was used to track her locations or her movements. And it led to another grisly discovery up just in this area here. A board was found under a tree. That board had Gannon's blood on it. This is miles away from the Stauch family home, which is in the southeast part of the city, close to the airport. You'll learn through testimony that this board came from the Stauch family garage. Then took more deliberate and thoughtful action. She loaded the suitcase containing Gannon into the back of a rented van and drove to Florida. And that's the course of her travels from here to Florida. She rented a hotel room in Pensacola, Florida on February 4th, 2020. She drove a short distance from that hotel room, which is sort of by those blue angular marks on the map, up to where that red square is on the map. Drove a short distance from that hotel room, across a dark bridge that drives over a river that flows into the Gulf of Mexico. There she acted with determined purpose. Stopped that van. She hauled the suitcase out of the back of that van, drug it to the side of the road, hoisted it up over the railing, pushed it over the side, hoping that Gannon would never be found. 48 days later, 1,300 miles away from where Gannon was murdered, the search for answers and Gannon's remains finally ended on March 17, 2020, when the suitcase that came from that basement storage room, Gannon's remains, blankets, and the pillow were found by an unlucky bridge worker checking that bridge for safety. And imagine the shock that he felt when he realized what was inside that suitcase. Inside that suitcase, obviously Gannon's decomposing remains. Also, these 2 blankets and that pillow. Remember the pictures that I showed just a moment ago of Gannon in bed? These pictures were taken by this defendant on the morning of January 27, 2020. Sent them by text message to Gannon's father, Al, who was in Oklahoma for training. Take note of those blankets. Take note of the blankets that were recovered from that suitcase. The very same blankets and pillow that were in those pictures on January 27, 2020 were found 1,300 miles away with Gannon underneath that bridge. The defendant then purposely, intentionally came up with numerous different stories about what had happened. Gannon was missing. Went to a friend's house and never returned. Gannon was kidnapped and she was raped by a guy named Eduardo. Gannon was kidnapped and she was raped, but this time by a guy named Quincy Brown. She went to look for a bike up near that Douglas County, El Paso County line. Gannon test rode that bike, crashed, and suffered a horrible head injury. And a guy named Quincy Brown takes Gannon, and now the defendant doesn't know where Gannon is. Cartels were somehow involved with Gannon's disappearance. And most cruelly, that Landon Hyatt, Gannon's mother, was involved with Gannon's disappearance. All of her actions were purposely designed by her to distance herself from what she did. Throw off investigators, buy her time, escape accountability for what she did to Gannon on January 27, 2020. At the conclusion of the evidence that we'll be presenting in this case, you'll be asked to determine whether the defendant is guilty or not guilty of the charges that we've leveled against her. You'll also be asked to determine whether she was sane or insane at the time that she killed Gannon. All of her decisions, all of her deliberate actions betray her claims of insanity. She knew that what she had done to Gannon was wrong. Why hide it? You'll hear her own voice through recorded phone calls and interviews. The evidence itself will prove her sanity. As jurors, part of your job will be to determine how much credibility, if any, you give to the witnesses. That same rule applies to expert witnesses. You'll get to hear from doctors. You'll get to hear from GPS.
Eye into the woods official, how are you? But it had to be done because the error is such a structural error. You cannot have a juror who son-in-law is the deputy district attorney under the prosecutor who is speaking right now, okay, Michael Allen, sitting on a jury, deliberating on a jury in the, you know, if you care about the judicial system, due process and everything, that's wrong. It's wrong. And I know that, yeah, we're upset because of who it is, but it should never have been done. And it's the judge's fault. It shouldn't be, you know, that's what's going on. That should have never been allowed. That is such a structural error. So, yeah, I mean, terrible.
Expert witnesses. Lawyers get tongue-tied sometimes. And when they take the stand and take an oath, you get to judge whether what they are saying makes sense. Is it credible or not? And if it's not credible, you get to discard it. If it's credible, you can use it in your deliberations, but you all get to decide whether that credibility extends to that witness or not. The same will hold true for our expert witnesses and the defense expert witnesses. Get to hear from a doctor that will testify that the defendant was insane at the time of the murder of Gannon Stauch on January 27, 2020. With all expert witnesses, you should gauge what they're saying, measure it against the other evidence that you're hearing. Does it make sense or not? Like all expert witnesses, if it doesn't make sense, you can discard it. You'll also hear from others who knew her best. People that have the best opportunity to see how she was acting. Did she understand the difference between right and wrong? Could she form intent? People like Al Stauch, the man who was married to her. People like her brother, Dakota Lowry, who flew out here after Gannon went missing. And most importantly, her very own daughter, Harley Hunt. See, Harley Hunt was in the best position to know the defendant's state of mind, especially as it relates to when this crime occurred. She was the only other older person in the house. When Al left to Oklahoma, Harley Hunt was working. She's young, 17 years old at the time, thinking about going into the Air Force.
After 4 decades of compression socks, here's what I'll never do again. Okay, so here's 3.
But she becomes the defendant's closest confidant after the defendant killed Gannon Stauch. In fact, she also rode with the defendant on that van ride from Colorado Springs to Florida. She'll be able to tell you in her own words, whether the defendant understood the difference between right and wrong, whether she could.
See, now I'll tell you regarding her daughter, Haley Hunt. There's a lot of, Haley was 17, right? Going on 18 or so. And she actually went out for her mother and got the carpet fresh and cleaning products with the sister, with Gannon Stauch's younger sister, okay? And while her mother was doing this intense cleaning and all of this stuff, okay? And some people felt, I'm not going to mince words, some people felt that Haley knew what was going on, okay? Now, whether Haley had to comply because her mother was so dangerous, or whether Haley truly was in the dark and didn't know this extensive cleaning that her mother was doing and ripping out carpet and all of this stuff, okay? Going with a U-Haul to Florida with a suitcase, going to a hotel, then going back, dropping it off over an overpass, then going to South Carolina, all of that stuff. You know, you have to take it for what it is. Did she have any idea? Did she not say anything because she was scared of Letecia or what? But there, you can't deny that people thought that her daughter might have been privy to what was going on, especially what was going on with the conflict with Letecia and Gannon. Okay, I'm just going to say that.
Act intentionally or deliberately or not. And she'll tell you that she could on both counts. Remember, this case is about two people. Gannon had no choice what happened to him that day on January 27th. The other, this defendant, she held every single decision in her hands. She took deliberate, thoughtful actions that ended a precious life and tore a family apart. Your job as jurors will be to listen intently to all of the evidence. Because even the most mundane evidence, it might seem inconsequential when you're listening, is being given to you purposely so that you can make the determinations you need to make as jurors. Did she understand the difference between right and wrong? Was she able to form a culpable mental state? Every single piece of evidence that comes from this chair will be used by you to make that determination. The next time I get to talk with you directly the way I'm doing right now, that'll mean we've concluded evidence and we're giving closing arguments. At that time, both sides will get to ask you to make determinations based on what you all have heard. We're going to ask you to hold us to our burden of proof. The criminal justice system doesn't work if you don't hold us to our burden of proof. Our burden of proof is proof beyond a reasonable doubt. The things we have to prove are the elements of the crimes charged. We also have to disprove that the defendant is insane, meaning essentially we have to prove that she was sane. The evidence will do that for you. We will ask you to give justice to Gannon Stauch. We will ask you to find this defendant guilty for what she did to him more than 3 years ago. We'll ask you to find her guilty of murder in the first degree, murder in the first degree of a child under 12 years of age, tampering with a deceased human body for taking Gannon's body from that scene and transporting it across the country, and tampering with physical evidence. We'll ask you to convict her on each and every one of those charges, and the evidence will guide you towards those convictions. On January 27, 2020, 6:55 p.m., the defendant herself called 911. She called 911 to report that Gannon was missing and not come home. Call taker, you'll hear, ask the defendant, who was the last person to see Gannon?
Who was the last person to see him? I guess me.
The evidence will show that she was the last person to see Gannon alive. The evidence will show that she was sane on January 27, 2020, when she ended Gannon's life. The evidence will show that she acted intentionally and deliberately when she took Gannon's life. And then we will ask you to convict her. Thank you.
Oh gosh, I remember how her defense attorney rocked and rocked in that chair through the whole trial.
Mr. Cook?
Good afternoon, members of the jury. I talked to some of you during jury selection over the last couple of weeks. To some of you, I want to reintroduce myself. My name is Will Cook. I, along with Mr. Cellini, represent Letecia Stauch. Now, this is a very tough case. We looked at the jury questionnaires, prosecution.
It's interesting. He says we looked at the jury questionnaires.
Strong feelings. Questionnaires. Have you formed an opinion about Ms. Stauch? Had a lot of she's guilty. Had a few she's evil. People forming opinions about this case before they ever hear one shred of evidence. As a defense attorney in this case is very worrisome when people have come in and they have preconceived notions of what's going on. With respect to the question on the paperwork that you got about insanity, what do you think about insanity? Is it valid? Something that's legitimate? A lot of people said sanity is just a way to get out of taking responsibility. It's an excuse. It doesn't exist. It's fake. Got a lot of
Experience the future of home security with our AI-powered camera, now yours for the price of a cup of coffee.
that. So I, as the defense attorney, have two big problems in the case. I represent Ms. Stauch, who, according to a lot of jury questionnaires, is evil and guilty. And us raising insanity is a bunch of BS. A lot to deal with. Been looking at this case for going on 3 years now. All the photos, I've seen all the reports Mr. Cellini has. It's a lot. What you saw on the board this afternoon, that's the PG stuff, the rated G information, photos you're going to see. For a general audience, go forward in this case, you're going to see the autopsy photos. You're going to see the photos of when Gannon was brought out of the suitcase. And they're horrible. Horrible. It was an awful, awful thing that was done to Gannon. And I see Mr. Allen get up here and he's emotional, almost into tears talking about it. And I get it. I get it. What happened to that little 11-year-old boy is beyond description. The facts of this case. Awful. You know, it's so bad. This is a lost cause. Ladies and gentlemen, I can't quit. I can't leave this courtroom. I've got to do my job in this case. Mr. Toledo does. I can't just, after that opening statement, all the information that I've seen, the photos, the smiling picture of Gannon, hearing about him being shot and stabbed multiple times, hundreds of witnesses, and 800 pieces of evidence that are going to come in. I can't check out now and just sit down and write this out. I can't do it because it wouldn't be fair. It wouldn't be fair to the court system, the process, and it wouldn't be fair to Ms. Stauch. And I know people will say, well, who gives a shit about what's fair for Ms. Stauch? The court systems do. The law does. The Constitution.
They didn't
Bill of
hear,
Rights.
right? They didn't hear.
The war fought over these things that we're dealing with today. Old school laws, the presumption of innocence, right to remain silent, stuff that comes all the way back from old Boston and Paul Revere riding through the streets on his horse going, the British are coming, the British are coming. Old stuff, and it matters. And once we decide something in the media, before you have heard one shred of evidence, prejudge this case before anything has taken place, then all of that is lost. And we are truly a country that is no longer ruled by law, but by the media. I get it, we've lost. Mr. Toledo, we lost. Stauch, we lost. We have lost in the court of public opinion and the media. He's guilty. I get that. This is a court of law. As Judge Werner said, come through those double doors there. This is a special place. This isn't the media. This isn't Facebook. Wash all of that away. Don't try to get up and walk out of the courtroom before you started.
I have these outside. They do really well in the
Do your jobs. Listen to the evidence. When the evidence is complete, go back into the jury room and weigh the evidence. All I'm asking of you, just give us a fair shake. I can see it in your eyes, ladies and gentlemen. A lot of you, as far as you're concerned, I could burn in hell for representing Ms. Stauch. A A lot of you won't even make eye contact with me. I might as well just be the devil himself up here running his mouth. But I'm not. No different than those three at that table right there. Paid advocates. Werner here in voir dire says they are paid advocates. Leanie and I, we're paid advocates. They have their side of the story. And I just want to be heard. Want our side to be heard. And if at the end, guilty, but you weighed the evidence, you listened, you didn't prejudge the case, your biases, your sympathies, your prejudices that you had at the beginning of this trial, if you didn't let those come in, were fair and impartial, but it's still guilty, I'll take that. I'll take that in a case like this. A lot of evidence. Very, very difficult case. So don't quit on me. Now, Mr. Allen is right. He's a good attorney. He's well-spoken. The elected DA. This is going to come down to insanity. Lady here and was killed back in January 20. How do you figure that out? How do you look into the mind of a sick person and divine what they are thinking? Well, evidence, people's statements, observations, recorded statements.
Brawler, it's time!
All heard Ms. Stauch talking on. That's good stuff. What else can you look at?
What was that? That was weird.
Motive? Somebody's motive.
Here she is, right here.
Remember that word? Up every day during jury selection for the past 2 weeks by the prosecution. Motive. You were told, and rightly so, by the prosecution that there is no requirement for the prosecution to prove motive. They're right. Does that mean that motive doesn't matter? No, it doesn't. Not mean that. Even though jury instruction talking about insanity, the prosecution just put up on the board, talked about motive or lack of motive could be a sign that there is insanity or not insanity. And it's in the jury instruction there. So it does matter. It's not required, but it matters.
No, Jen, the juror did disclose that. It was totally disclosed. It was totally disclosed. He said his son-in-law is the deputy district attorney under Michael Allen. The judge knew it, Jen. The prosecution knew it, and the defense knew it. And yet, he was allowed to sit on the jury and deliberate in this case. That's what everything that I was going through, all of that, is all about that. Just want a quick synopsis. I just updated the video description with a layman's terms of what happened here. And maybe I'll just read that again for you guys because it's very succinct and explains what's going on, okay? There was a structural error. It's a juror conflict. The core of her appeal was about a juror they called M.B., whose son-in-law worked as a deputy district attorney in the same office that was prosecuting Letecia Stauch. Under Colorado law, if a juror is related to one of the attorneys in the case or someone in their office, they are considered impliedly biased. So there's an implied bias. They don't have to prove whether there is a bias. It's implied as a matter of law. During jury selection, the defense challenged the juror for cause, meaning, hey, aren't you, don't you have someone that's working in the district attorney's office? They asked the judge to remove him because of this relationship. However, the judge refused to dismiss the juror. The judge thought the juror could be rehabilitated by promising to be fair. The appeals court ruled that because the bias was implied by law, due to the relationship, the judge was required to remove him immediately. Why does this mean there's a new trial? Because the juror M.B. actually sat on the jury and helped deliberate and reach the verdict. The court classified it as a structural error, and in the legal world, a structural error is so fundamental that it infects the entire framework of the trial. So it prevented Letecia from her right to a fair and impartial jury of her peers. And it cannot be ignored. Therefore, the original guilty verdict was thrown out. It was overturned. And then there was a small victory for the state where the search warrant that wasn't thrown out there, okay? And 2 of the 3 judges voted for this. There is also the opinion of the 3rd judge that I read. So that's all in the video before this, just so you know.
Matters, and it matters because it's evidence. You don't have a motive, that goes to show a lack of evidence. Say there's
Donna's loving the sound of selling and earning on Vinted. Don't wear it, sell it.
I'm not really a cupcake, but I am super baked, thanks to Mood Can.
Mood is third-party tested.
a couple people involved in a shooting and a murder out in the community. Paper reports it as a random, senseless act of violence. One person shot to death. Police investigate. They have 3 people that are suspects that were there at the scene at the time of the shooting. One problem for the investigators. Don't really have any other evidence. A week later, doing some good police work, they uncovered that one of the 3 people was a drug dealer who was ripped off the week before the shooting by the dead man. A lot of money and drugs were stolen. All of a sudden, with that information, this random, senseless act of violence becomes a murder with a motive. It does matter.
You need to put it up. It's not hooked up yet. You can turn off the perimeter lights if you want. I'm not getting a feed come through. You are hooked up to the defense. Still not coming through. Oh, there you go.
Enlarge that or?
That's what you're looking for, right?
That's the photo. Ladies and gentlemen, if you will turn your attention to the two boards, screens. This fancy pointer that you were alluding to, Judge. Extendable. All right, we've got a photo here. We've got some familiar looking faces. Gannon, Letecia Stauch. Stepmom, stepson. Gannon's little sister in the back. You look at that. Looks like everybody's doing pretty good. Happy, sunny day. Maybe Miss Stauch is doing a selfie, holding the camera out. Whatever. When would have this photo been taken? The day before Gannon died. The day before he was killed. It wasn't a photo of evil, anger. A photo of someone, by all accounts, who was a loving stepmother, care of Gannon. Gannon's father was on a deployment. Stauch worked as a teacher herself in the Whitefield School District, an elementary school teacher. Got a person that was, living what seemed like the American dream in a nice suburban house in Morrison Ranch, the suburbs of Colorado Springs, Colorado. But behind those photos and Miles, Stauch. Oh,
Yeah, I did.
okay. Stauch was hiding. Stauch was dealing trauma and abuse that had been going on since she was a toddler. A troubled childhood. Mother wasn't really much of a mother. She had a line of stepdads or boyfriends or whatever. Her mother, come in and out, come in and out, in and out, in and out of her life. From the time she was 3 or 4 years old, Miss Stauch, until she finally moved out. And she suffered. She suffered horrifically from these stepfathers, these boyfriends of her mother.
See, Dollar Shave Club just has great razors at a great price and no bull.
Want to flush out its swollen legs? Stop doing this first. I'm going to show you something about leg swelling that might surprise you.
Watched her mother get beat by the boyfriends, physically abused, until eventually the physical abuse these men reserved for her mother eventually trained on Ms. Stauch here. Little girl. First, it was just physical beatings, whoopings, emotional abuse, verbal abuse, and then it became sexual, where she was molested regularly. Five or six until she was a teenager. Constant. She used to have to sleep in the car out in the driveway to get away, not have to molested and sexually assaulted by these men. Sleep in the car in the driveway of her house. And because her mom wasn't around a lot, it's kind of an absentee mom. A lot of these stepfathers, if you could call them that, cared for Miss Stauch exclusively. Mom was out somewhere doing something, gone for several weeks at a time. And Miss Stauch, as a young child and a young woman and a teenager, was left in the care of these men. How do you deal with this? You're 6, you're 7 years old. What do you do? Physical abuse, sexual abuse, emotional abuse. How does a kid handle that? Well, a lot of people that have had bad childhoods go on and they're fine. There's some that don't. Some is a survival mechanism. Some of these children's personalities fragment. And why do they do this? This fragmentation of the personalities when there's abuse at a young age. Because in the case of Ms. Stauch, her abuser was also the person that provided her means for survival. A 4, 5, 6-year-old kid does not go out and get a job and work and acquire their own food, pay the electric bill, pay the rent. So while they're being abused, they also, as a matter of survival, have to both hate and love, to fear and placate their abuser / caretaker. How does a person do that? Well, I think in a lot of situations, no one person can do that. That's where the fragmentation personality comes in. All the good and all the bad, all the evil and the hate can't reside in one place. And I know some of you, based on your jury questionnaires, think I'm telling some fanciful tale about this. I get it. I read the questionnaires. But As such, you have sworn an oath multiple times to follow the law and the evidence. Don't like insanity or dissociative identity disorder? That's okay. Joke or an excuse or not valid? That's okay. It's okay if you think that.
Yeah, but for due process, it's the right thing. Nobody that wants due process and our legal system to be fair can look at this and say it's wrong, no matter who it is. You know what I mean? Because it's Letecia, and we know she's guilty, and she's going to be convicted again, and all of that. You cannot discount that one of her deliberating jurors' son-in-law was the deputy district attorney under Michael Allen, who was prosecuting this case. You cannot say that that's okay. And it's a structural error that the judge erred. And it shouldn't be that a defendant has to clear up the judge's error, curative, with the to strike the juror, because it's not, the judge shouldn't be making an error like that. Okay, that is, I don't care, what the juror says, that they can be impartial or whatever. There's an implied bias, and you can't have it. And it should have never happened. And whether they want to say the defense should have used their strike and it was strategic, yada, 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 it's the judge that should have, that's causing this. Absolutely. This added expense, trauma, and everything falls on the judge. It does. It does.
But outside those doors, in here, you got to believe it's a legitimate mental health defense, that in fact it exists and that it is scientifically backed. You're going to hear doctors, sworn experts on both sides. So yeah, it's in the DSM-4 or 5, which is the book of psychological ailments and issues psychologists and psychiatrists use to diagnose things. It's listed accepted in the scientific community issue, a real issue, dissociative identity of multiple personalities. Now, whether you believe or their experts believe what our expert believes about whether it was present in this Stauch's case, different issue. But you must, to be fair, impartial, and unbiased, you must believe that it is a possible defense. It is a valid defense. It is a valid defect or disease of the mind that triggers the insanity provisions under the Colorado laws. Laws that trigger when we bring in some testimony or some evidence that there is insanity causes the rules, the laws to pivot. So that the prosecution has the burden of proving beyond a reasonable doubt let's say.
If you're just getting here, I put a layman's terms. I'll read it. It's in layman's terms in here, but it's really succinct and it'll tell you exactly why she's getting a new trial. Here, I'll just read it to you really quick, okay? It's a structural error. It's a juror conflict. The core of the appeal is about a juror that they call M.B. in the 54-page document that I did read in its entirety, whose son-in-law worked as the deputy district attorney under the prosecuting attorney, Michael Allen. Same office, okay? That's prosecuting Letecia Stauch. Under Colorado law, if a juror is related to one of the attorneys in the case or someone in their office, they are considered impliedly biased, meaning there's an implied bias. It doesn't have to be proven bias. As long as it's implied, it's a matter of law, and it's a structural error. During jury selection, the defense called this out, right? And prosecution acknowledged it. Judge knew it. It's not that someone didn't know this, they knew it, okay? But they asked the judge to remove him because of this relationship. However, the judge refused. Now, they would have to use one of their preemptive challenges. They didn't use that, but they can't be at fault because they didn't take the juror out when this is a structural error and the judge should have taken him out. So whether they want to say it was strategic on Letecia's part not to request an extra preemptive challenge to get him off, or use one of the ones that she did, you still can't hold a defendant responsible for being curative in a judge's error, right? So you can't have it. The judge refused to dismiss the juror, mistakenly believing the juror could be what they call rehabilitated by promising to be fair and impartial. The appeals court ruled that because the bias was implied by law due to the relationship, the judge was required to remove him immediately. The judge made a structural error. And because Juror M.B. actually sat on the jury, actually deliberated the verdict that convicted her, the court classified it as a structural error. In the legal world, a structural error is so fundamental that it infects the entire framework of the trial, and it can't be ignored. So she lost her right to a fair and impartial trial, and that's something that we don't ever want to happen to anyone, no matter of who it is, right? Therefore, the original guilty verdict was thrown out. That's the crux of this, okay? And that's why the family has to go through this again, and everybody does. And it's all because of that. And I hope my mic's on and you can hear me. Let me just make sure my mic is on and you can hear me.
Her
Hold on.
abuser.
Hold on. And it should have... Okay, good. All right, I get so paranoid with this mic. All right, let me listen.
Day 57 of wearing hollow compression socks. Here's what nobody tells you. I am wearing hollow compression socks every...
In this case, circle back around. Why all of that just matters. Going back to motive. Evidence. Exhibits, photos, videos. We're going to be in here for 8 weeks. School's going to be out. Making plans for our Labor Day barbecues. Not Labor Day. Barbecues by the time we get done. But you know what you're probably not going to hear? During all that time with all those exhibits, all that evidence. All those witnesses. You're not going to hear about a motive. You're not going to be given a motive about why Ms. Stauch. January.
Welcome. Who's that? Hey, Lerpa. Yeah, you say the judge should have to pay for the trial if he chose to let this person stay on the jury, right? Yeah. He's not, though. He's not, though. The taxpayers are.
2020.
Well, in a way he will, but you know what I mean.
He probably has some kind of insurance.
Reason is
Not going to pay for the
there's
trial.
no motive.
Probably insured.
There is no reason. Doesn't make sense. It's insane. Smiling photo. Next day, Gannon's gone. No reason for it. Prosecution may say, oh, well, makes it that more tragic that it was such a pointless death of Gannon. I don't know. I'm not going to speculate on that. But there was some major psychotic crack that went on during this time. Go from teacher, loving stepmother to 2 children, loving mother to her own child, Harley, a person that Gannon's father entrusted his own 2 kids, watched and loved and by this woman here. Being a killer of a 11-year-old boy. How do you get there? Big jump. There is no explanation for it. I don't have one. She broke on that day, ladies and gentlemen. She broke. Broke from all that was right. Made sense. And the axe, putting Gannon's body in a suitcase and traveling 1,300 miles, whole of Florida, and throwing the suitcase, Gannon's body in it, side of an oak. She was raped by somebody. The person who raped her kidnapped Gannon. Hear all the stories. The prosecution's going to play it for you. These are all signs and evidence of a mind, a soul that is broken, most fundamental and profound way. So broken, doesn't even know what it was doing. What was going through that person's head? The killer Gannon's head. Stauch's head. All the stab wounds, the shootings, the bruisings, the beatings, the burns. What was going through that person's head? I don't know. I don't know.
Take your bra off and switch to this one now. This bra lifts your bust like no.
I couldn't tell you. For the person that she was killing that day, attacking, I wasn't Gannon. I wasn't Gannon to her. Wake up that day and go, I'm going to kill her. No. She was killing the demons. Her life from the dark depths of her childhood and her life. And here, different doctors. We have a Dr. Dorothy Lewis. She's from Yale. She's been at it a long time. An MD, got a lot of experience with this. Her legal medical opinion is that on the date of this offense, Ms. Stauch was legally insane. Now, the prosecution is going to have some witnesses from our state mental hospital in Pueblo that I imagine are going to say, no, she was perfect. She knew what she was doing. It's normal behavior for a person to do that. Yeah, she had some mental issues and everything like that, but everybody does, but they don't know he killed an 11-year-old boy. And that is true. A lot of people do have mental health issues. It was talked about in voir dire. Will have very severe mental health issues. They don't go out and kill people. They don't go out and kill 11-year-old boys or their stepsons. They had had a nice hike just the day before, as evidenced by that photo. Don't stab the stepson dozens of times. Discharged 3 bullets, a 9mm handgun at the boy, hitting him once, killing him once. Beat him, burn him, and do all these other things you're going to hear about. Wrong, and it's horrible. She not sane. And she will be held accountable. Not guilty by reason and insanity. We'll get a jury instruction. It's about a paragraph long. It indicates in that case, and I think Judge Warner alluded to it, to one a panel of potential jurists in the last couple of weeks. She's found guilty, then it's guilty. She's subject to regular sentencing by the court. But if I'm not guilty by reason of insanity, doesn't mean she walks out of here. She's committed to the state hospital, Colorado Department of Human Services, and they take over from there, the state mental hospital. That's not what we're dealing with here now. So I know there is a natural urge, human urge, a real urge. You hear about that little boy with that big bright smile that you saw on the screen. Hear about what happened to him. Want to make somebody pay. Want to make somebody pay dearly. Not right. Happened to that young. Awful. But not providing doubt, constitutional protections for presumption of innocence, the right to remain silent, placing the burden of proof squarely on the shoulders of the prosecutor, letting
Donna's loving the sound of selling and earning on Vinted. Don't wear it, sell it.
Choking happens in seconds, and most homes have a fire extinguisher, a first aid kit, but nothing.
Bias or sympathy come in, cloud your judgment. Not going to bring Gannon back. Prejudging the case by what you've heard in the media.
This guy takes so many pauses that I'm keep checking to see that it's running.
And we know it's terrible. But just listen to the evidence, as I started out with. Don't check out. It's gonna be easy. Went into week 6, hearing all these witnesses and looking at evidence. You're gonna wanna check out.
And this is going to be a long trial again.
You're gonna wanna form your decision.
I'd like to go to this trial. I would. It's going to depend on when it happens, but that is a trial. It'd be a long trial. It's a 6-week trial, I think it was, right? Was it? I think that he said 6 weeks. Yeah, I think we started this in April and it ended like the middle of May. Crazy. I would like to go. I don't know if that'll happen.
Decision soon in this case. But you can't do that. For the next 6 to 8 weeks while we're in this trial, you can't form an opinion. Warner was telling you that. You're in an evidence gathering phase now. You're gathering the facts. Like Judge Warner's Miss Denver omelets. This is the ingredient gathering stage.
Oh my gosh, he's comparing it to Denver omelets.
It's in the cooking stage.
Cooking
when you go back
stage.
to the jury room after all the evidence is in. Start putting the ingredients together. For omelet, or just a ham and cheese omelet.
Oh yeah, I'm confident
Whether you've
too.
got a guilty,
I said
not guilty.
I said the same thing. There's not a doubt. There's not one doubt in my mind she's going to be convicted again. Not one doubt. That's not what I'm worried about. She's not going to get off. They didn't get the search warrant thrown out. All the evidence is going to come back, and there's probably going to be additional evidence because they're going to be allowed to use these whatever jail calls and stuff that may have happened since this trial. They may be able to pull that in. Who knows? Even without that, she is guilty as all. Come on, she's guilty as all get it, and she's going to be convicted. But yet, everybody's got to go through this again. This pain, this torment, this traveling. It's just horrible. Now the Gannon sister is older, right? This is 3 years. It'll be by the time it goes to trial, it may be 4 or 5 years. Yes way, Julianne, yes way. I thought it was no way too, and if this would have happened yesterday, I would have said somebody was doing April Fools or something. It's first thing I said to Scooter when I saw this. I said, no flipping way. And it is. And then I thought, okay, it's just emotion. No, she's getting a new trial. It's a structural error, Julianne. And if you look at it and you care about due process of law, you know it's right. The judge is the one that really erred here. And but the prosecutor should have known too. I mean, come on. They can call it strategic or whatever on her part, whatever, but it's not up to the defendant to do that. So, yeah, Julianne, I can tell you real quick. I'll tell you I'll give you I went through the 54-page document, every bit of it, but I'll tell you real quick. I put this in the video description kind of in layman's terms. So it was a structural error that is causing this new trial. It's a juror conflict, right? The core of the appeal is about this one juror that they call M.B., M like Michael, B like boy, in the documents. Now, their son-in-law, it's a male juror, and their son-in-law worked as the deputy district attorney. That's what I said. It's not somebody that was clerking there on an internship. It's not somebody like even, whatever. But it was literally the deputy district attorney in the same office as the prosecutor, Michael Allen. And who was prosecuting, sitting right there, prosecuting Letecia Stauch. Under Colorado law, if a juror is related to one of the attorneys in the case or someone in their office that's considered, there's implied bias. You can't have it. And you have to, eliminate that person. Well, the judge didn't. And the whole thing was, well, shouldn't she have used, one of her challenges and got them off? She had, I think, 16 of them. She could have asked for an extra one, but it shouldn't be left to the defendant to do that, even if you want to say that they're being strategic or whatever. During jury selection, the defense did challenge this juror. See, some people think they didn't know. Yes, the defense knew who this person was, the prosecution knew, and the judge knew. Okay? They asked the judge to remove this person based on that relationship. The judge should have done it. It would have been a done deal. However, the judge refused to dismiss this juror, mistakenly believing the juror could be rehabilitated by promising to be fair and impartial. The appeal court ruled that because the bias was implied by law due to the relationship that he had to, God bless you, to the prosecutor, the judge was required to remove him immediately. That means she gets a new trial because that juror, M.B., actually sat on the jury and actually, God bless you, deliberated to decide the verdict. And so the court classifies it as a structural error in the legal world, and that is fundamental, and it is immediately overturned. There were 3 judges on this. 1 disagreed. I did read that, but 2 majority rules, and the original guilty verdict is out. It's out. She's out. Done. I mean, she's not out of jail. She's not out of prison. But her conviction is overturned. Done. She gets a new trial now. She wanted this search warrant to be suppressed and stuff on there, but they didn't. That was a small win for the prosecution. Anyway, she gets a new trial. So this starts all over again. I hope that's clear, Julianne. Yeah, I went through, if you want to listen later, the whole 54-page document, every bit of it. But now I'm just playing the opening statements because people that are not familiar with this case, they can get a quick synopsis of what happened here.
Or not guilty by reason of insanity based on the evidence, the ingredients. When you're in the jury room, that's when you start putting it together. Just writing down, taking notes, taking it all in. Why the judge mentioned several times to you today, I don't want y'all talking about the case amongst yourselves.
See? Dollar Shave Club just has great razors at a great price and no bull.
This is what would happen to your body if you ate mood sleep gummies every day. Day 1, you take your first gummy.
Kind of a special, hidden, quiet place, this courtroom, especially you jurors. Don't want you.
They knew it from the get-go, Bucky. They knew it. It was not a secret. It's not something that's come out. They knew this. That's the thing. They challenged it during jury selection, and the judge is like, no, he can stay.
Y'all talking about the case because that leads to deliberating and judgment. It's in the judgment phase. So, thank you for your time. Thank you, everybody, for coming back. We'll be spending a lot of time.
I don't know who keeps
together
clearing their
over
throat.
the next couple months, so
Next couple months.
keep an open mind. Put a lot of the bad stuff
Okay, sit down,
out of your mind for now.
Rocky. Yeah,
The prosecution has to say, hear what the defense has to say. At the end of this, as Mr. Allen said, when he's concluded his opening statement, said, I'm going to come back in a couple months and ask you to find her guilty. Hire Mr. Tellini in 2 months. I'm going to ask you to find her not guilty by reason of insanity.
Okay.
Now the trial starts.
Yeah.
And opening statements, you've had all that now. He said, and I said, it's not evidence.
Nope.
Checked it up on the board and the videos and the audios that he played. That's not evidence. Or what the judge said. If you had to deliver a verdict right now, it's not guilty. Woman right here is not guilty. He's presumed innocent. Not telling you to like it. I'm just telling you that's the way it is.
That's how it is now, right? You're not telling you to like it, that she's getting a new trial. It's the way it is, and it's the way for the due process, the legal system to work right and justly for all. It is, it's wrong. She did have her rights. Her rights were violated. They were, and regardless of how you feel about her, if you care about the legal system, it is just to give her a new trial.
I'm going to stop now because I'm running out of steam.
This
But
guy, he's going to go rock in his chair.
Do appreciate your time. I know the judge is due. Said earlier, you're the ones that are making the sacrifice. You're the ones that, are losing money because you're not able to go to work. That, if your workspaces, your offices are idle, you're going to be here for 2 months. What we do, this is where we work, all of us, the attorneys, we pay.
His mic keeps cutting out when he...
They're the ones that make the sacrifice.
She's in the corner all the way over there.
In this case. And I do appreciate it.
Fairly Farmhouse.
And on behalf of my attorney, Mr. Tellini, I know he appreciates it. Thank you.
Todd, can you get the last perimeter link, please?
And that's the judge that made the mistake there. Okay, so I think that was just the opening statement.
Do it again.
All right, I can't find my one for... Okay, but yeah, I mean... So, what do you think about that? I wonder how long it'll be, right? Before they have a new trial set up, right? I wonder if that has any reason why the discovery in the Letecia Stauch case is thousands and thousands of dollars. Do you realize that still is thousands and thousands of dollars, hundreds and hundreds of dollars for different pieces of it? It's ridiculous. El Paso does have an issue with wanting, I think they do want to really turn a profit on this discovery, which they're not supposed to do, but that's my opinion, okay? Opinion of others. But yes, I've never seen discovery as expensive for FOIAs, when you FOIA as Letecia Stauch still to this day. And maybe that's because they knew there was eventually going to be a new trial. I don't know. I need the simple summary. Yeah, I gave you the simple summary. For those that don't want the simple summary, there's the 54 pages that I go over. But yeah, I couldn't believe this. I literally said to Scooter, this cannot be true. And I really thought it was a joke. And then April Fools, I mean, man, this is just crazy. Crazy, because when have you heard of something like this? Especially such a long trial to be redone. And I'm thinking, is she going to go for any kind of a plea? I don't know. What kind of plea is she going to go for? Death penalty is already off the table. I don't know. something to spare the family. I don't know, or she's going to go full out, drawn out, another 6-week trial. It's crazy. But anyway, thanks for coming in on this Thursday, Holy Thursday. It's rainy and cold here in New York. And tomorrow's Good Friday. And then I haven't done anything about getting this stuff. It doesn't just, Easter's coming. It's not that, it's been earlier, this, but yeah. Just, anyway, I will see you guys later tonight. We'll talk about this more, I'm sure, and whatever else. Thank you for coming in. Please hit the likes. If you could share out the video, that would be great to help our algorithms. And I appreciate you coming in here to watch. And if you're rewatching, I appreciate that too. You can hit the likes then, please. And I'll see you later on. All right, everybody, have a good evening. I'll be on in a couple of hours. All right. If you're new to the channel, I know there are some new names, if quite a few, and you've just subscribed, make sure you hit the bell for all notifications. You too. I'm going to get your name wrong. Is it? Is it? Why am I getting your name all wrong? Okay. I'm just going to call you L. Because I don't want to say your name because it... Okay. Anyway, I'll see you guys tonight. Thank you so much. And bye now. God bless. May the Lord bless you and protect you and give you his peace. And as I say, pray for everyone in your community. Everyone needs prayers. There are a lot of people going through stuff, always. All right. Take care, guys.